For reasons mentioned in the judgment, the proceeding of PRC case number 1290/2023 are hereby quashed and this criminal petition is allowed.
Delivery of order item number 2.
For reasons mentioned in the order, the petitioners are allowed to go on bail of ₹1 lakh with 2 sureties of like amount, subject to certain conditions.
I'm obliged.
Item 3.
For reasons mentioned in the order, the petitioner is allowed to go on bail of ₹1 lakh with 2 sureties of like amount, with subject to certain conditions.
Hello.
Yes.
Two criminal petitions in nature, madam. Day after tomorrow.
Criminal petition senior court is there, I think.
RS.
New filing.
New one.
Okay.
Last week.
Okay.
Dropping the lordship with an anticipatory bail. They are government officials, my lord. If it is not inconvenient to your lordships, can it be at 2 o'clock?
When have you filed?
Today it has been filed.
What is the
But
urgency?
the urgency is that they are the PWD, one executive superintendent engineer. There is one FIR which has been not against them. Against the contractor, he has been picked up because one child had fall. Because there is a manhole, it is a fault of the contractor. Ultimately, we are the engineers. So ultimately, that's the whole problem. Where will we are here itself? So there is an apprehension in our mind. So if it is not inconvenient, if it comes, your lordship kindly take up my lord at 2 o'clock. If it is not inconvenient, your lordship.
No, the problem is we are already full in our list. We are unable to take up the listed matters.
But if possible, my lord, at 3 of, if we'll try, my lord. If
Tomorrow.
possible. Today, tomorrow there is some difficulty. I'll be out of session. That is why. Otherwise, I would not have trouble your lordship. If it is
Oh.
possible.
Okay.
Yes, I'm deeply oppressed.
May I please, your lordship, I beg to mention for listing AB 1905/2024, lordship. Lordship, matter was fixed today but not listed, lordship.
When do you want?
Lordship, day after tomorrow.
Okay.
Highly obliged.
Yes. Also, I beg to mention a criminal appeal in the criminal petition. But a criminal petition for admission and criminal appeal also for admission. It was listed on the lordship last Friday, but due to paucity of time, matter could not be taken.
I am unable to hear you.
But criminal appeal for listing, it is a fresh case.
Fresh case.
Lordship earlier listed on Friday, but it was taken up paucity of time. And a criminal petition for
When do you want?
Thursday.
Thursday. Okay.
All right.
When have you filed?
Tomorrow.
When have you filed?
Filed on 19/3/24. I want to withdraw my.
Or you want to withdraw?
Withdraw.
Okay.
May it
Yes.
please the lordship. Item number 62. I have taken the consent of the CBI council lordship. Could it be taken up after next week? It is my prayer petition IA, where I have requested for release of the passport.
You have taken consent.
Yes, lordship.
62. Heard Mr. D. Soikel and its senior counsel appearing for the applicant who prays for an adjournment of this case due to personal difficulties. He also submits that he has obtained the consent of Learned Standing Council CBI, who does not have any objection to his prayer. Hence, the prayer is allowed. Let this matter be listed.
Next Monday, lordship. It will be
Next Monday,
15th.
15th.
It will be 15th.
Listed on
15th or this Friday also.
15th.
15th, lordship. Deeply obliged.
May I please your lordship. May it please your lordship, Malada, 4 years conviction, Malada, IA filed for suspension of sentence. 7 occasion, Malad, it could not come before the court. Malad, 1 year, more than a year, I have been inside the jail. Let it be listed on Friday, Malad. Oh, no, Thursday, Malad,
Thursday.
because Friday is a holiday.
Okay, Thursday. Okay,
Under the criminal petition, there was some defect, my lord, filed in the month of June. Can it be witnessed, my lord? Passing for a, my lord, FIR, which is absolutely, my lord, an abuse of the process of court.
okay.
Deeply, miss.
May I please your lordship? But this I was fixed on 29/8, my criminal appeal, my lord, that matter is not listed, my lord. It is in jail, my lord. So maybe come upon 11th or 15th, any day, my lord.
15th.
I am obliged.
Please, your lordship, beg to mention because listing of I in criminal petition, my lord. He has been behind the bar for the last 118 days, my lord.
Yes.
I am, my lord, he is behind the bar in NIC.
When do you want?
My lord, on 10th, on earlier visit to has been listed but could not reach.
15th.
My lord, it will be 10, my lord.
15th.
Orders money, it orders.
For what purpose you want list?
For bail, my lord. Body parties are already shareholder differences, my lord.
Criminal,
NIC case.
criminal appeal.
No, my lord, and a revision petition, criminal revision which in the NIC case. He was convicted and sentenced in 138 of NIC, my lord. He has been behind the bar for 118 days, my lord.
15.
My lord. Now, I have the same here, my lord. I also criminal appeal, my lord. And this matter has been listed twice, not this, my lord. He is behind the bar for the last 168 days, my lord.
15th.
Sir, please, your lordship, to mention for listing of a bail application, your lordship, for withdrawal, your lordship.
Tomorrow.
So, lordship, today or at any time today, because already a charge sheet has been submitted.
Okay.
May I please say, other thing also for listing, my lord, criminal petition, my lord, motion, my lord, on Thursday, my lord.
When have you filed?
My lord, in the month of May, my lord, but some to do difficulties or objection.
Okay, on Thursday.
Thursday.
Yeah, please, your lord. Item number 53, lordship. I have inquired, lordship, CD not received. Can you go on Monday, lordship, 15? Early entry may continue, lordship.
Item number 53.
53, lord.
Heard Mr. A. Sharma, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who seeks some more time for production of the case diary. Let this matter be listed on 19th of October.
Okay. Apply. May I please, your lordship.
20 October. 22nd October.
May I please, your lordship. Lordship, I beg to mention a listing of a criminal revision petition, lordship. This pertains to maintenance, lordship. I am for the wife.
When have you filed?
Lordship, I am for the respondent, lordship.
When have you filed?
No, file is filed by the petitioner, lordship. I have received notice and I have filed my objections also.
So it will be listed automatically.
No, lordship, it is not listed already. I have filed my objection 2 months back, lordship. It's not listed. So
Okay.
let it be next week, any day, lordship. As per lordship.
Next week on a date to be fixed by this.
Next week on the date.
My please, your lordship. Lordship, I beg to mention for listing 2 criminal petitions. My lord, one date before the learned trial court is, my lord, 16. May I pray on 11?
Okay, on 11.
And
May I please, your lordship. Now that I beg to mention item number 56, AB matter, lordship. CD was called for, but CD has not come today. But there is no interim order, lordship. I am praying for listing on next Monday, lordship, 15.
No, that depends on when they can produce the case.
This Monday.
Heard Mr. M. Khan, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who's praised for some more time for production of the case diary. Let this matter be listed 16/9.
Yeah, please, your lordship. I beg to mention for listing of the RA in a criminal revision petition, lordship, for recall of warrant, lordship. Lordship, kind of matter will be listed on the day after tomorrow, lordship. 10th of September, lordship, day after tomorrow.
15th. 15th, we Otherwise, it will not reach.
Kindly 10th Lordship.
16th. Let it be on 15th.
May I please your lordship, I beg to mention item number 31. Engage counsel Mr. Judicial, some personal difficulties. Lordship, kindly this matter taken up next week.
Heard, Mr. What is your name? You have
Jay
informed
Islam.
the council, NCB council. Heard, Mr. What is your name?
31. Jay Islam.
J. Islam, learned counsel for the petitioner who seeks an adjournment on the ground of his personal difficulty. Also, Ms. M. Deka, who does not have any objection. Learned counsel for NCB who does not have any objection, hence the prayer is allowed. Let this matter be listed in the next week on a date fit to be fixed by registry.
Madam President, Lordship, I beg to mention item number 52, Lordship. Perhaps CD not visible.
5-2.
Yes. I'm not on internet, Lordship, I only have a short bit. Yes, for CD not visible.
Heard Ms. E. Kolita, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who seeks
17-9, madam.
some more time for production of the case diary. Prayer is allowed. Let this matter be listed on 17th of September.
May I plead your lordship? I have filed additional affidavit in item number 64. Right? Let me come on record now.
Call for the additional affidavit.
Published.
Please, your lordship. I beg to mention one criminal revision petition in Boston Borough
When have you filed?
in 5th September.
When have you filed?
5th September.
5th of next week, Monday, Tuesday. 17th.
May I please, your lordship? Item number 22. I request for one accommodation because today I left my file, that is. So it may kindly be fixed on by tomorrow. Item number 22.
Yeah.
Entry order is already there, that may
You have
kindly be-
from the other side.
I could not able to inform, but entry order is there, that may be extended, but
We
I
will-
left the file today. It
We
may
will
kindly-
allow it, but not now. When the matter is called, we will allow your time.
Much of-
May I please, your Lordship? I beg to mention for listing of a matter. Lordship, last week we filed 2 bail application. One has been listed in tomorrow's daily list and one has not been listed. Both pertains to one case diary and same FIR. Let the matter be listed together, your Lordship, tomorrow.
Okay.
Highly obliged.
May I please, your lordship? I beg to mention for listing, your lordship. It's a criminal revision petition, your lordship. Last time listed on the 10/4/2025.
15.
15.
15.
16 is the fixed for trial court, your lordship.
So 15 is
13.
okay. 15.
15. Okay, massively.
I beg to mention the bail application for Lordship.
When? Okay.
May it please your lordship. Lordship, I beg to mention for listing a bail application for Wednesday for motion, lordship. I have filed it on 3rd of September, lordship.
Okay.
Oblige your lordship.
What is the Lordship? I beg to mention for listing criminal petition 517/2025, Lordship. Lordship, matter was listed several times but never reached Lordship.
When do you want?
10/9, Lordship.
Okay.
Highly obliged.
Lordship, I beg to mention item number 37 of the daily list. Lordship, considering Mr. F. Bothakur is out of station. On that account, Lordship may kindly adjourn the matter for the day. And can it be fixed on next Monday, Your Lordship?
Heard, Mr. What is your name?
E. Khatoniya.
E. Khatonia, learned counsel for the petitioner who seeks an adjournment on the ground that the conducting counsel, Mr. S. Babs Thakur, is out of station.
It be available, madam.
Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that the case diary is available. Stop. Considering the submissions of learned counsel for the petitioner, the prayer is allowed. Let this matter be listed on 18th. Let the case shorter days. 16th. Let the case diary be retained till next date.
May I please, Lordship? Lordship, I am praying for listing a criminal petition which was last listed August 23, Lordship. August 2023.
Next week at the date. 17th.
Please, your lordship, I beg to mention item 46, lordship. Lordship, my senior counsel, Mr. AKB, has some personal difficulty today.
Heard, Mr. What is the name?
NR Sharma.
N.R. Sharma, learned counsel for the petitioner, who prays for an adjournment on the ground that the conducting counsel, Mr. A.K. Bhuya, has some personal difficulty.
Lordship, would it be after application?
You are on interim.
Lordship.
Case diary is there.
Well, here CB is available, but not in this code, it is in code number 22. There are other matters also, Malad, because of that, Malad.
Okay. Considering the submissions made by learned counsel, the prayer is allowed. Let this case be listed on 22nd of October.
Second, there will be some difficulty.
October.
October, they will file, he will be out of station, lordship, on 22nd. Will it be 23rd?
23rd October.
Should the interim order make?
The interim order shall continue till next.
May I please, your lordship? Lordship, I beg to mention item number 55, lordship. Lordship, POXO matter, lordship. Service report upon the respondent is awaited, lordship. 55.
You have seen the office note. Heard Mr. D. Medhi, learned counsel for the petitioner, also heard Mr. K.K. Parashar, learned additional public prosecutor. It appears that the notice issued to respondent number 2 has not yet been served. Learned additional public prosecutor is requested to get information regarding service of notice on respondent number 2 from the officer in charge of jurisdictional police station, and let this court know about the same on the next date fixed. Let this case be listed
CD may be retained, but
short date. 16th.
in the meantime, CD may be retained.
The case diary shall be retained till next date.
Deeply available.
May I please, Your Lord, item 2023, anticipatory bail, I may be allowed to withdraw with a liberty to file a fresh. Something has to add, my lord.
Heard Mr. C. Goswami, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw this anticipatory bail application. On what ground you are
Well, something has to add, my lord, some.
due to some technical defect, the prayer is allowed. Liberty is always there.
Kindly, liberty may,
No, there is no bar in,
of course, my lord.
therefore liberty is not required. And what is not required is not
My lord,
granted.
May I please, lordship, I beg to mention, my lord, for listing a criminal petition, my lord. And date of last listing was, my lord, 13/8/2024, my lord. So some urgency.
24th
Yes, my lord. So, my
next
lord,
week.
my lord,
18th.
15 is the date was fixed for, fixed in the, my lord, landed trial court below, so kindly before 15, my lord.
11th.
I love that.
May I please, your lordship? I beg to mention item number 50, your lordship.
50.
Yes, your lordship.
Yes.
The CD has not been received yet, your lordship.
Yes, Malad, CD not.
Heard
However, we
Mr.
are granted the privilege of interim bail, your lordship.
What is your name?
P.S. Chaudhary.
Heard Mr. B.S. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this matter be
Your
listed
lordship, interim protection is there.
on 22nd October.
Can it be 6th of October, your lordship?
No.
22nd would be. It's holiday.
22nd October. The interim order shall continue till next day. Yes. Yes.
Your lordship.
Lordship, I beg to mention, criminal appeal for listing, lordship. It was last posted on 29 November 2024.
24
Yes.
next week. 18th.
Your lordship, I beg to mention one criminal revision petition for listing, lordship, in hearing column, lordship.
In hearing column.
That's posted on 29/5 and supposed to be listed on in the month of July, lordship.
Next week.
Item 4.
I did lordship, application under section 483 BNSS, charge sheeted case lordship. 3 witnesses have been examined. Thereafter, further investigation has been ordered. Although FOXO is there, but victim refused to give consent for medical examination. And as further investigation has been ordered, he has been custody since 14/5/2025. That means earlier charge sheet was not, investigation was completed.
How many accused are there? Only one?
Only 3 witnesses have been examined, including the victim. Victim was, they were examined on 6/8/2025. But after recording the examination chief of victim, it was
Where is the order of further
Yes.
investigation? In the midst of trial?
in the midst of the lordship page 46. This is the rejection order, there it is mentioned. Last part, perusal of case report shows that by order dated 12/8/2024, prayer of the IU for further investigation was allowed. As such, I am of reasonable opinion that the releasing of the accused on bail at this stage may hamper further investigation.
When the charge sheet was laid?
Justice was laid on 17/6/2025. Then charge was framed on 25/6/2025.
And after that, further investigation was?
No, after 3 witnesses were examined on 6/8/2025. And lordship may kindly come to page 40, lordship. This is the last part of victims examination chief.
Procedural lapse appears to be there. How further investigation can be directed in the midst of trial?
Midst of trial,
We are issuing notice,
at this stage and
scan copy,
Can copy and.
Can you have the case record?
as well as the case diary. Heard Mr. S.D. Purkasta, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification of the registry within 3 days from the date of this order, returnable on 14th of October.
Lordship, can it be before puja, lordship?
Before puja, we are
Even 27 will do, lordship, 27 or 26. Or then 25.
possible. 26th.
March.
Let also the scan copy of the records of special POXO case number 57/2025, as well as the case diary of Silchar Police case number, scan copy of the case diary of Silchar Police Station case number 502/2025 be called for. Registry to take steps for requisitioning the scan copy. List accordingly.
Item 5.
It's a charge sheeted matter, my lord, diary, LCR may be, TCR may be called.
Heard Mr. N.J. Dutta, learned counsel for the petitioner. Also heard Miss
Yes, Chakraborty.
P.S. Chakraborty, learned standing counsel, Customs Department. Let the scan copy of the trial court records be called for. Let this case be listed on 14th of October.
6 here, my lord, diary may be called for, my lord. It's from Dilai, my lord, Karbi Anglong.
Diary before vacation.
Diary before that.
Heard Mr. N.J. Dutta, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Call for the case diary.
19 minutes.
Let this case be listed on 19th of September.
I'm obliged.
Item 7.
May it please your lordship. In this case, I have been accused under section 18B of the NDPS Act.
Lordship, if I may, with your lordship, to the FIR, which is a page number
It is
8,
a charge sheeted case.
charge sheet has not been filed.
No. City,
When is the date of your arrest?
23rd of March 2025. It's already almost 170 days.
18B is commercial quantity of opium.
But your lordship, the fact is that I was not present at the site. I
We
am
will call for the case diary.
Yes, your lordship.
Heard Mr.
G.R. Datta.
G.R. Datta, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Call for the case diary. Let this matter be listed on
Gosaigaon PS.
25th of
May it please, your lordship. 483 PNSS application, my lord. And this is a started NDPS, my lord. At this stage, trial court record may be called for.
heard Mr. Yu Khan, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Call for the scanned copy of the records of the trial court. Registry to take steps for the possession of this. Let this case be listed on 15th of October.
Deeply. Mind.
May it please, your lordship. Lordship, 483 application, lordship, in connection with Gosaigaon PS case number 99 of 2025, in lordship, under section 20B of NDPS. Lordship, Lordship, petitioner is behind the bar since last 57 days, in lordship. What?
We'll
57
fix
days,
it after 3 days
lordship.
and let him find out whether charge sheet is been heard. Mr.
Muhammad A. Rahman, your lordship.
Mr. A. Rahman, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Let this case be listed on
Thursday, my lord.
11th of September. Let the case diary be called for. I am calling for the case diary, but you may
Status. Where is CS file?
take the information. List accordingly.
Highly obliged.
Yes, your lordship. But a subsequent application, my lord, in earlier, my lord, it was rejected, my lord, observing that, my lord, some vital witness are yet to be examined.
Also case.
Yes, my lord, and after, and direction was given to file before the learned court below, after examining the material witnesses, my lord. And after that, my lord, all the materials witnesses have been examined, I filed, but there was rejected.
Why?
My lord, rejected, my lord, kindly see the order, my lord.
No, why it was rejected?
Because this is a case of seriousness.
Okay.
And my lord, another submission, my lord, in the meantime, my lord, one quick use, my lord, who is similarly situated, he already has been released by this honorable court, my lord. I have annexed the order also, my lord. Page 83. Grounds of arrest are also not communicated.
Heard Mr. S.H. Sigdar, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Call for the scanned copy of the trial court records. Let this matter be listed.
Only short date, my lord, because other quick use have been already released, my lord, and grounds of course.
Other co-accused do not stand, does not
Copy
stand.
of- and notice also, my lord.
And my lord, grounds of arrest were also not communicated.
25th September.
Notice also, my lord.
It will be there if it is there. Oh, yes,
No notice.
yes, issue notice to the respondent. Number 2, the petitioner shall take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order, in pursuant to the prevailing notification of the registry, returnable on 25th of September.
Some 11. Yes. Short date. Name.
It will go after October if you insist.
Obliged.
May I please, your lord? My lord, 483 application, my lord, offense under section 6 of Procedural.
Heard Mr. A.K. Azad, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Issue notice to respondent number 2 The petitioner shall take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 25th of
August.
Any.
24
24th of October. Also call for the, it is a charge sheeted case. Also call for the case diary. List accordingly,
24th September.
September.
Publish.
Item 12. Number 483, my lord. Plus case page kind of 20B2, my lord, B. And 25 the NDPS sector, 53 days behind the bars. FIR is at my lord, 8.
We are calling for the case diary. Heard Mr. M. Dr. Learned Counsel for the petitioner. Also heard Mr. K.K. Parashar, Learned Additional Public Prosecutor. Call for the case diary.
17, my lord.
Let this matter be listed on 17th of September.
13.
Wait. Also is there.
Heard Mr. M. Mandal, Learned Counsel for the petitioner. Also heard Mr. K.K. Parashar. Charge sheeted or
No.
K.K. Parashar, issue notice to respondent number 2. Baki khini likhibo and call for the case diary.
25.
Let this matter be listed on 25/9.
Item 14.
The regular bail application, my lord, 21B, my lord, marginally above the small quantity, 6.78 gram suspected.
Since when you are behind the bars?
I am behind the bar for last 17 days, my lord, 22/8/2025. He was arrested, my lord, 4 days remand, my lord,
What is the contraband? Heroin.
heroin, my lord.
We are
6.8
calling for the case diary.
for that.
Heard Mr. P. Hajorika, Learned Counsel for the petitioner. Also heard Mr. K.K. Parashar. Let the case diary be called for. Let this case be listed on 18th
18.
of September.
I am obliged. Item 15.
May it please your lordship. Lordship, this is a regular bail application, lordship, 59 days in jail custody. Though lordship case was registered under commercial quantity, but the lordship peruse the FIR, that is Panchnama lordship. There lordship will find Tahir Ocean, the seized material recovered from the Tahir Ocean. He was waiting in the platform number 3 lordship. He said he has to deliver it to the petitioner lordship. It is from the concise position of the Tahir Ocean, not from this to petitioner lordship. Thereafter, lordship 67.
Case diary.
Short date, lordship.
No short date.
Because next week.
Heard Mr. B. Chaudhary, Learned Counsel for the petitioner. Also heard Ms. M. Deka, Learned Counsel for NCB. Call for the case diary. Let this 18th of September. 18th September.
Highly obliged.
Highly obliged.
16.
Lordship, matter may be passed over for time.
No.
Lordship, my senior will.
No.
Heard Miss, what is her name?
Yes.
S. Nazreen, Learned Counsel for the petitioner. What is the matter?
PCX is there, my lord, 7A of PCX.
Lordship, senior will appear. Lordship, please.
No, when you have appeared,
Sitting need to be called, my lord, otherwise PCX.
who will be appearing here? No, whether special public prosecutor or you will be,
SCB will be here,
you will be appearing.
anti-corruption.
It is pending investigation.
Yes, my lord. Arrested on 19.
Yes. Let the case diary be called for. Let this case be listed on 19th September.
Item 17.
483 application, commercial quantity of ganja seized from the.
Investigation is going on or
Yes. And,
we'll call for the case
yes.
diary. Heard Miss M. Dev, Learned Counsel for the petitioner. Also heard Mr. K.K. Parashar. Call for the case diary. Let this matter be listed.
It's not.
Yes, only.
24.
24th of
Yes.
September.
All right.
I'm sorry, madam. I don't know item.
I have called for the case.
Yes, madam. And the short date was, I don't know what.
We have given a short date.
19,
Continue.
next week.
Only your lordship might have seen, my lord. 20 days already 5,000 rupees, my lord. With the further custody, I am only on that, my lord. I was
No, let us wait.
already your
Yeah.
lordship. 19.
19.
They may be recorded. my- Oh, you already. Oh, she was there. Obliged.
Please, your lordship. The petitioner before your lordship is BDP secretary lordship. And he is also a fisheries and also several cultivable lands. His grandfather was a landowner of one LP school, another ME school, and also PHE lordship. And due to this political pressure, there was a case whereby this honorable court granted him interim bail lordship. Kindly see,
You are on in,
one kindly let lordship.
since when you are behind the bars?
Since 24th lordship of August. What happened? When I
Oh.
got an interim in an unknown accused one FIR lordship, as per this order, as a law-abiding citizen, I went to deposit this, record my statement. When I went there, they made me sit in the police station. Then in another one old Dakaiti case, they have shown me as arrest lordship. Kindly see, and in the forwarding report, it is reflected.
Why your prayer was rejected by the trial court?
No, trial court, because the affidavit was not filed and that was in a casual manner, and on the day of production, it was on a very casual. Kindly see, I have annexed it. Because without affidavit, and since it's a session triable case, that's why a learned CGM has rejected.
Okay. We are fixing a short date.
Don't you kindly say one on the forwarding report, it's reflected their malified intention,
Yes,
lordship.
yes.
And kindly, before coming to forwarding, kindly, lordship, I briefly apply for that. Lordship, kindly see on page 26. Page 26, lordship.
Yes.
Page 26. In one affair, a man burnt his shop, and in that case, totally unknown. And you see, as per this page 28, relevant portion, lordship, the petitioner shall cooperate in the investigation and appear before the IO for recording the statement. This order was given on 18th. Accordingly, from on 28th, I went with this order to appear before the IO. Kindly see, lordship, page 13. Page 13.
1-3.
1-3, lordship. In that case, I got this intent protection from this honorable court. Page 13, last life,
No, okay. You got interim protection in a different case.
different case, that's also unknown. No accused name is there. And accordingly, when I went there, when they saw this interim protection, kindly see forwarding, there they say that I am FIR named accused of that accused. I am a robber. Kindly see, then lordship may kindly see annexure 1, lordship.
Page.
Page 11. Oh, sorry, 12. Page 12. That is my appointment letter given by Superintendent of Police.
No. In which case you are arrested now?
Now in Dakaiti case, page 13. This is such a hideous crime, lordship. It's a shameful act, lordship. This
Page
present
17 is the.
17 is the relevant long one. I'm not on FIR.
No, why you have been arrested?
I have categorically stated in paragraph 6.
No, that is your story that you were granted bail in a case. Then when you went to the police station, you were arrested in a different case.
Different case.
That is your story. Now, in the different case, what are the materials against you?
That's why I'm saying, your lordship, it's such a heinous crime, such a shameful act. They ought to have asked for 1 day at least for police remand for interrogation. Straight away in the forwarding report, it's reflected. No police remand, nothing. Straight away to judicial custody.
But Unless we see the case, where is the rejection order?
Rejection order is annexed. Rejection order by Ladakh CGM lawsuit.
Yes, where is that?
Page, page 32. Page 33 is the relevant book. Page 32.
Your name is Akram Hussain Ansari.
Answer, yes, sir.
Yes, we are fixing a short date. Calling for the case diary. Case diary perusal would be necessary.
Only one clerkship forwarding report to answer clerkship.
Okay, what do you want to show?
Can you fill the forwarding report? Clerkship, can you see at page 29? Yes, a very shameful like the FIR with which I am arrested, lordship.
Yes.
Can you see, lordship, on the third line, a prayer to remand him to judicial custody for a period of 14 days. No police remand, nothing in such a heinous crime of
So
Parity and all.
therefore your submission is
Interrogation. Again, come the next page, lordship, paragraph 4,
paragraph 4 of
page 30 of same forwarding report, continuing page. Page 30, that the arrested accused person is a veteran criminal and he has been found involved in other criminal. He's the FIR named accused of Dwarban PS case number 36.
yes, that may not be a reason for.
Lordship, but in the FIR itself, it's shown that unknown, no name has been mentioned in that FIR, lordship, in where I got an interim page. Secondly, because I have that's why I annexed those cases.
When can you produce the case diary?
From proctor 19.
19. Heard Mr.
Obliged, lordship.
Heard Mr. N.S. Laskar, Learned Counsel for the petitioner. Also heard Mr. K.K. Parashar, Learned Additional Public Prosecutor. Considering the nature of acquisition made in the FIR, this court intends to peruse the case diary before considering the instant bail application. Hence call for the same. Let this matter be listed on 19th of September.
Much obliged.
Item 19.
Well, the offenses under section 22B and other subsection of BNS. At this stage, CD may be called.
Mr. I. Rafiq, Learned Counsel for the petitioner. Also Mr. K.K. Parashar, Learned Additional Public Prosecutor. Call for the case diary. Let this case be listed on 19th of September.
Right.
Item 20. Made plea gender.
Lordship, FIR at page 18, Lordship, the case has been registered under section 4 of the POCSO Act, Lordship. Notice has to be issued to be.
Mr. R. Islam, it is pending investigation.
No, sir. No, that has been filed and Lordship, charge also framed.
Victim has to be examined. Let the victim be examined.
11th,
For
evidence.
11th of September. Heard Mr. R. Islam, Learned Counsel for the petitioner. Also heard Mr. K.K. Parashar. Let the notice be issued to respondent number 2. In person, stop. The petitioner shall take steps for issuance of notice upon the respondent in pursuant to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 23rd of September.
Lordship, kindly please on Lordship, he is 22 years old.
23rd of September.
Notice has to go.
Notice, Lordship, I'll take a step.
When do you want?
Today only. Notice.
No, when do you want the listing?
18 or 19.
When is the next date fixed?
Next date fix is 11, Lordship, 11/9. or evidence.
Good, so. 19.
And Lordship, one more thing, Lordship 47 and 48 notice me.
On 19th, we will see.
Lordship, that may be called for, Lordship will peruse on that.
No, it is, it will be there, it will be there in the case diary.
Item number 21.
None has appeared for the petitioner on call. Let this matter be listed day after tomorrow. And
Item 24, 22, item 22.
22 may mention, I say. You have not brought, she is praying for an adjournment. Heard, Miss,
It may kindly be fixed tomorrow if there is not.
not tomorrow. Kitea fix koribo pare. Date. Heard. Next week, it will go on next week. Heard Mr. I. Rafiq, learned counsel for the petitioner. Also heard Ms. M. Kumari, learned standing counsel CBI, who prays for an adjournment, who prays for a short adjournment due to some personal difficulty. The prayer is
Though the
allowed.
CD has come, my file is not there, so just, that is right, though I am trying to prepare, but I need.
Prayer is allowed. Let this matter be listed on. Then fix kore diyo. 17th of September.
Interim order may be continued.
The interim order shall continue till next week.
Item 24.
Much of.
My Lordship. 480 BNS, your Lordship. FI is at page number 10, your Lordship. Allegation is, your Lordship, one, Abdul Raf Khan, son of Dolat Khan, resident of Kalija PO, Kalija Moza, Bedbari, PS, Howley District, Borpeta, has accused three persons, namely Abdul Rahman, son of Nilazul Rahman, Rafibul Islam, and Sahidul Islam. I am here today on behalf of your Lordship, Raqibul Islam. Now the allegation is, your Lordship, the residents of accused number 1 and 2, Kalzar PO, Kalzar Moja, Bedbari PS, Howli, District Borpeta, Assam, residents of accused number 3, Haripur PS, Tarabari District, Borpeta, Assam. So with due respect, the information backs to inform that his minor daughter, namely this date of birth 3/7/2010, is currently studying in class 9 in Kalzar.
In September.
Let me
No, no protection.
Item 25.
Name, please, Your Lordship. Lordship, this is a petition for anticipatory bail. And the reason being page 14, I've got a section 35(3) notice to cooperate with the investigation. Lordship, page 14. And Lordship, I am nowhere related to the incident except a phone call that was made by the driver.
What is the offense?
So Lordship, page 16 is the FIR. Basically, the offense is that the informant hired truck to take tin sheets from Sonapur to Silchar. On 14th of August, the truck was hired. It went to, it loaded from Sonapur, then it went via another place, Behabari. It loaded further tin sheets.
Why you failed to appear on 3/9?
We filed our, because of apprehension of arrest, Your Lordship. Lordship, may kindly see the reporting, forwarding report, page 30.
30.
Yes, Your Lordship. The driver and the person in whose house some of the tin sheets were found were arrested, and this is the forwarding report. And in that forwarded report, they have already declared us as absconding, and this is dated 24/8. Whereas our 35 notice is 29.8. So our apprehension is they've already deemed us to be
What is your name?
my name is Shri Kalyan Pator.
Where is that in
Should
page 30?
Page 31, 2. May I read page 31, 2?
Yes.
During the course of investigation, it has been revealed that the arrested accused being the driver and the person in whose house steel was recovered. In conspiracy with the driver of the vehicle, the owner of the seized truck and other associates have hijacked the truck bearing so-and-so loaded 16.5 tons of sheet by affixing a fake number plate. And as per the lead and disclosure of arrested accused Utpal Das, who's the driver, 187 pieces of sheets were recovered from the house of co-accused Haskar Shettia, who's the other person who's arrested. And further investigation is established that a large nexus of accused persons were involved in the commission of the offense, including absconding accused, namely Kalyan Pator. Worship, I'm a businessman. I'm involved in transportation of earth from Sipsagar to Nagaland. I happen to know the truck driver. The truck had some problem in Sipsagar while it was on its way from Sonapur to Nagaland. So the truck driver, knowing me, called me up and said, there's some problem in the morning. So I said, okay, fine. From the motorable road, put it inside. Thereafter, I went to Nagaland and I discovered that there has been some kind of a theft. Other than that, I'm not the owner of the truck. I'm not the owner of the tin sheets. I'm not a customer. I'm nothing, no way related. Just one call was made to me.
Which date this 24/8?
Yes, 24.
And the notice to
Notice was 29/8. Or should I find that at page 14?
But,
28/8, sorry.
for the other cases, CB already called.
when?
I have forgotten, but might be, I have seen the FIR, but.
My instructions are that the two persons accused in page 30, arrested person are already on bail. The driver and the person from whose house it was recovered. Archib, I have no hesitation in going before the IA and being examined. My problem is I don't want to be arrested when I'm trying to cooperate. That is the limited protection.
Anything?
Because they've declared me to be absconding without even contacting me. So it looks like
the whole consignment was not recovered, half of the portion recovered from one person, and there may be entangled by other persons, may be involved, huge quantity things were stolen and subsequently sold to other persons.
Goswami, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner Shri Kalyan Pator, who is apprehending his arrest in connection with Sonapur PS case number 130/2025 under section 303 within bracket 2/317 within bracket 2/318 within bracket 4/61 within bracket 2 of the BNSS. What is the next date? Disposal.
This one AB 212525, Mantas Khan and Nawaz Hussain. It is move on 29. Now fiction 24/9.
Show me the order.
I have seen the FIR.
okay, who's gonna have one for you?
List of accusation from page.
But in that case, their name were not there because of that interview was done. Now, in
List of accusation from
names of the
Para
parties.
3 and from AB case number 2125/2025. Spelling mistake, I say. Sabu. I have marked it. Para 4. Learned counsel for the petitioner has submitted that petitioner is a businessman and is in no way connected with the offense alleged in the FIR. The driver of the seized truck happens to be an acquaintance of the petitioner. You allowed to keep the truck where?
We did not allow, it was on the motorable highway. We asked, because I'm from there. So we said, okay, come inside and I'll help you come inside. Then the driver himself took it to Haskar. What is that?
Okay.
Haskar, the accused.
Acquaintance. However, she submits that
Haskar Chetia.
the
That was the
petitioner has received a notice under section 35 within bracket 3 of BNSS from the investigating officer of the case, directing him to appear before the investigating officer on 3/9/2025. Learned counsel for the petitioner submits that the petitioner did not appear on the said date as he apprehended that he may be arrested if he does so, as even as on 24/8/2025, that is prior to issuance of notice under section 35(3) of BNSS to him, when one of the co-accused, namely Utpal Das, when two of the co-accused, namely Utpal Das and Bhaskar Setia, were produced before the Court of London Chief Judicial Magistrate Kamru, in the forwarding report filed by the investigating officer, the present petitioner has been shown as absconder, which raised the apprehension that if he appears before the investigation now in pursuant to the notice under section 35(3), he may be arrested. Stop. Learned counsel for the petitioner has submitted that in the instant case, some of the co-accused persons are already granted the protection of interim bail by this court. And the case diary is called for in those cases. And the next date is fixed on 24/9/2025. Learned counsel for the petitioner also submits that the petitioner is ready to cooperate in the investigation. However, as he is apprehending his arrest, some interim protection may be granted to him. On the other hand, learned additional public prosecutor has also submitted that in a connected anticipatory bail application, in which two of the co-accused have approached this court, that is AB 2125/2025. This court had granted interim bail to those petitioners and fixed 24/9/2025 for case diary. He submits that in the instant case also, the case diary may be called for. Stop. Let the case diary be called for. However, in the meanwhile, considering the submissions made by learned counsel for the petitioner, as discussed in the foregoing paragraphs, the above named petitioner is directed to appear before the investigating officer of Sonapur PS case number 130/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions 1 and 2. Place this case on 24/9/2025 along with AB case number 2125/2020.
Six on same date, so 24/9.
24/9.
Nice.
Maybe so Lordship, I'm for item 21, Lordship. I'm sorry, I missed it when it was called for. Regarding the matter, Lordship, I want to withdraw this matter.
Heard Ms. J. Ghosh, item number 21. Heard Ms. J. Ghosh, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has prayed for allowing the petitioner to withdraw the instant anticipatory bail application. The prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
Much obliged.
Item 26.
May I please, Lordship? Lordship, it is a pre-arrest bail application, Lordship. Lordship, the present petitioner is not an FIR name accused, Lordship. Lordship will find the FIR on from page 13, Lordship. The only apprehension is that, Lordship, I have received a 35 earlier 41, Lordship, a 35 BNSS notice, Lordship. The FIR name accused is one Samima Akhtar, Lordship. May I read the FIR, Lordship?
Yes, page number?
Page number 13, Lordship, type copy, and page number 17. May I read from the type copy, Lordship?
Yes.
I am going to inform you that in July 2024, a Facebook account introduced as Samima Akhtar sent me a friend request and I accepted the friend request. Later on, I got suspicion about the Facebook account to be a fraud one by observing the activity going on in that Facebook account. Later on, the unknown accused person with the same name to manage to collect my personal mobile number and started messaging in my WhatsApp number so-and-so from her WhatsApp number so-and-so. I used to respond to that person message on WhatsApp in response to her message asking for help in legal matter. The accused person using the WhatsApp number mentioned as above stated to do video calls through WhatsApp. In one such incident, when I was occupied with some other work, I received the person's video call. Later, I got to know that the accused person had taken few screenshots of mine during that video calls and she sent some more photographs of mine which are obscene and vulgar in nature. The accused person has also threatened and tried to extort money from me on the pretext that she would send those more photographs to my family members, friends, colleagues, and senior officers of my department. Upon denial to such demand made by the accused person, have found that she has sent those more photographs to Facebook account and through the WhatsApp number so-and-so to the police personnel belonging to the different rank of Dorong district. When I presently posted this act has resulted in severe damage to my reputation, leading to defamation in the society. Now, Lordship, the complainant here is an OC of Mongoloi police station, Lordship. Lordship will find the 35 notice, which is on page 18, Lordship. While serving the 35 notice, Lordship, the police personnel has also prepared a seizure list, and by that seizure list, the 2 mobile phones were seized from the house of present petitioner, Lordship. Now, the fact is that, Lordship, the said mobile number, which was used by the FIR name accused, which is Samima Akhtar, Lordship, as part of Facebook account, which was which sent friend request to the said informant. The said mobile number was lost in the month of July from the petitioner's mother's hand, Lordship. And in the July itself, from the month of July 2024 itself, the said mobile number, by Facebook account, by mobile phone and by WhatsApp number, the said accused has been using the mobile phone, Lordship, along with the SIM, Lordship. Lordship will find my relevant submission on para 7, Lordship, on page 6, Lordship. Lordship, from the year 2024 itself, the OC of the informant, Lordship, the OC of the Mongoldo, informed it to the OC Zamuna Mukh. Then the OC Zamuna Mukh has informed me regarding the incident that the said number, which was earlier in your mother's name, is now used to do such activity. Now, as per the information of the OC Zamuna Mukh and also from the information of the informant, who is OC Mongoldoy, I have blocked the mobile number by giving intimation to the concerned service provider.
When have you blocked?
Lordship, I have blocked in November 2024, Lordship. After getting the information, it will be all part of a digital record, Lordship. Already my mobile phone has been seized, Lordship. And after then also the informant was constantly in contact with me. Thereafter also he has asked me that although you have blocked the mobile phone, now the WhatsApp has been used by the said Samima Akhtar. WhatsApp is still been operating. Then he told me to reopen the said SIM in my name again. Then I again contact the service provider and I again reopen the said SIM to block the other person from using that SIM as per the information of the informant, Lordship. Thereafter also I could not open the WhatsApp account because, Lordship, WhatsApp account is still being operated by one mobile and it cannot be operated from another mobile, which is the original owner.
No, you can block the SIM also.
I have blocked the SIM already in November 2024. Thereafter, in August 4, the informant has,
how WhatsApp is being used?
the WhatsApp has been used then also, but
Cannot be used from a different
it
number.
cannot be used by the but the informant, but the petitioner here tried to open the WhatsApp because it was opened in another mobile. It cannot be opened in my mobile phone. At that time, the informant called me and told me that go to a net cafe and try to open by using a desktop. Thereafter, in August 4, the account were again taken back, Lordship. And my mobile phone has already been seized. The informant is in constant contact with me. That particular CDR will come into the record, Lordship. Because
why are you apprehending?
Lordship, because the mobile phone was earlier in the name of my and the SIM was earlier in the name of my
when you
mother.
are asked to appear before?
I was asked to appear before, Lordship.
When?
Lordship, on 5th, Lordship.
Why did you not appear?
Lordship, because of the apprehension, Lordship. Lordship, the whole digital record, it is there in the public domain, Lordship. Let the statement of the petitioner be recorded to corroborate with the digital record, Lordship, because it will be a part of the digital record, Lordship.
Otherwise, Malad,
and he is a practicing advocate of Hojai, Lordship, Bar Association, Lordship.
that Malad, what I have noticed, Malad, that SIM, if Malad, no balance also, Malad, it can be Malad used in WhatsApp. WhatsApp messages come, Malad. For a new mobile, only verification is required. Otherwise, Malad, it may work, Malad.
Okay. Heard Mr. D. Medhi, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Rafiq Uddin Bhuiya, who is apprehending his arrest in connection with Mogoldoy PS case number 76/2025 under section 308 within bracket 2/356 of BNS, read with section 67A of the Information Technology Act. The gist of acquisition in this case is that on 3/5/2025, one Chandan Jyoti Bora had lodged an affair before the officer in charge of Mogoldoy police station, inter alia, alleging that in the month of July 2024, the informant got acquainted with one Shamima Akhtar through Facebook account. Later on, there were exchange of WhatsApp messages also between the informant and said Shamima Akhtar. However, it is alleged in the affair that the informant got suspicious as regard the genuineness of the said account, and he doubted that the account may be a fake account. He also, it is also submitted that the said person who introduced, who used the name of Shamima Akhtar, had taken some screenshots of the informant during video call and sent some morphed photograph of the informant, which are obscene and vulgar in nature. And the informant has been threatened and an attempt was made to extort money from him on that pretext. Learned counsel for the petitioner has submitted that the informant is the officer in charge of Mongolde police station, and the petitioner is a practicing advocate at Hojai. He also submits that the mobile phone of the petitioner got misplaced in the when
July 2024.
in the year July 2024, and there is every possibility that someone have
Petitioner's mother's mobile. It was used by the mother of the petitioner.
He also submits that the said mobile was earlier used by the mother of the petitioner. He submits that after the mobile got lost, there is every possibility of someone misusing the said mobile. He also submits that after petitioner came to know about the allegations, know about the
Allegation from Jamunamukh police station.
allegation of misuse of his mobile from the officer in charge of Jamnamukh police station.
On
He,
November.
he took steps for blocking the SIM of his mobile phone in the month of November 2024. When you got back your mobile,
I didn't got back my mobile.
how it was seized, from where it was?
It is another mobile, but the SIM was again, I contact the service provider, the earlier number which was there. I contact the service provider and they gave the same number with a different SIM.
Learned counsel for the petitioner also submits that after blocking the earlier SIM, the petitioner approached the service provider and he was given a new SIM with the same mobile number.
On August 2025.
In the month of August 2025. He further submits that the new SIM and the mobile has been seized.
Already been seized. It is a part of digital record.
Seized by the police. He also submits that the petitioner is in no way involved in the offense of circulating morphed, obscene photographs of the informant in social media platforms. And he is ready to cooperate in the investigation stuff. On the other hand, learned additional public prosecutor submits that considering the nature of accusation leveled in the FIR, case diary may be called for. Let the case diary be called for. Long date. Let this case be listed on 15th of October. In the meanwhile, considering the submissions made by learned counsel for the petitioner, as discussed in foregoing paragraphs, the petitioner is directed to appear before the investigating officer of Mongolde Police Station, case number
Lordship, 76 of
76/2025, within a period of 7 days from the date of this order and cooperate in the investigation. If he does so, in the event of his arrest in connection with the above noted case, he shall be allowed to go on interim bail of rupees 30,000 with one security of like
Deeply obliged.
with following conditions, list accordingly.
Deeply obliged.
Item 27.
May I please, Your Lordship? Madam, may kindly come to last order, 18th August 2025, which will clarify everything, madam. 18th August, last order.
Yes.
Where the personal appearance of the OC of all women police station was called for. And he could not answer properly, for which a status report was called for the Commissioner of Police, Kamrup Metro.
What is the matter? Yes, read the last order.
Mr. D.K. Nath, Learned Counsel for the petitioner and Mr. M.P. Goswami, Learned Additional Public Prosecutor for the respondent number 1, State of Assam. In defense to the order dated 4th of August 2025, MS Vijaya Das, officer in charge, All Women Police Station, Panbazar, has appeared in person. According to MS Das, officer in charge, All Women Police Station, Panbazar, there is no record as regard All Women Police Station case number 163 of 2019 in the police station, and despite searches being made, no record could be traced out. It is relevant to mention that the petitioner has approached this court by this petition after having failed to learn about the current status of the investigation of All Women Police Station case number 163 of 2019, which was registered on the basis of the FIR lodged by the petitioner as the informant on 14th of November 2019. The accused person named in the FIR was arrested in connection with All Women Police Station case number 163 of 2019, and subsequently he was allowed to go on bail by an order dated 6th of December 2019. Passed in bail application number 3745 of 2019 by this court on the ground that further custodial detention was not warranted for carrying out further investigation of the case. When the petitioner was first moved on 27th of May 2025, a status report was regarding All Women Police Station case number 163 of 2019 was called for. Thereafter, the case was listed on numbers of occasions on 5th of June 2025, 12th of June, 19 June, 27 June, 16 July, when the officer in charge All Women Police Station had failed to submit the status report. As regard All Women Police Station case number D. A copy of the report submitted by the officer in charge Badarpur Police Station dated 23rd of June 2020, actually it should be 25, addressed to the public prosecutor has been placed on record. As per that record, my lord, that is there, no case is registered in Badarpur Police, my lord. Thereafter, my lord, as per the report of the police officer in charge, Badarpur Police Station, no record pertaining to All Women Police Station case number D is available at Badarpur Police Station. A thorough examination of all official records of Badarpur Police Station was conducted, and after verification of record, it is found that no case corresponding to All Women Police Station case number D has been registered at Badarpur Police Station since 2020. There was neither any documentation to confirm the receipt of case diary, any related case files, nor any record of the court order transferring the case from the subdivision judicial magistrate Sadar, Kamrup Metro at Guwahati to Badarpur Police Station case has been found. From the photocopy of the order, which appeared to have been passed on 19th of November 2020, it transpires that on the prayer being made by the IO of the case, Ms. MS Daisy Nath, to transfer the case of All Women's Police Station case number D and
to Badarpur police station on the ground there, the place of occurrence would fall within the jurisdiction of Badarpur police station. A direction was made to send the case record to the OC Badarpur police station for registering a case and to complete investigation. The details of the court which had passed the order are not legible. The parties have failed to provide any further details as regard to this Parliament police station case number. From the material record on placed on record, it can be noticed that Parliament police station case number this and that was registered for offense under section 493, 325, 294, 506 of IPC. The offenses under section 325 IPC and section 294 are cognizable offense. The case record of such kind cannot remain untraced, leaving the informant aggrieved person at large. Mr. Goswami, learned additional PP, has submitted that he will inform the matter and obtain instruction from the Commissioner of Report, Guwahati. He has thus sought for 15 days time to place further instruction in this matter. List again on today. My lord, I'm of the observation that last order is not available in the in this file, my lord. I have seen the earlier order. Let the MP he may have information maybe there, my lord. After maybe call for after some time, my lord, I will inform.
Mr. Goswami is there.
Maybe he is.
Okay, let
after some time.
let him come. What relief you are seeking here?
My lord, initially I filed the court at case at Guwahati. Thereafter, nothing, no status report, no notice from the court or no charge sheet. Therefore, recently, 2 or 3 months back, the client contacted me. I personally went to the CJM court at Guwahati. There is not a single paper, no record was there. I personally verified the register. There is also that serial number is there, but name, offenses, nothing is there. So I went to the Oloman police station. There the second OC informed me that in the year 2020, the matter was transferred to the Badarpur police station. Now the thing is that the case was registered.
There must be some record of transfer.
That is there, my lord.
No, but Badarpur is saying that we don't have anything.
Again, just come to the Oloman, then they make an inquiry, and that maybe because she now by the services, she couldn't produce any receipt. Transfer the case to Badarpur.
Where you got these order sheets?
Which, my lord?
This photocopy of the order sheet which you have annexed at. Pagination is not there.
I have only placed one
1911-2006.
daily. I have not placed any orders in my petition. I have only placed one order of the High Court allowing him bail. I searched online, my lord, personally, as an advocate, as Annexer 3, my lord. And apart from this, my lord, I have
Okay, let Mr. Goswami come. We'll take it up
after some time.
after some.
28.
Yes.
Petitioner hearing your lordship is challenging the proceeding pending, NI case pending before the judicial magistrate first thing. Your lordship, I'm seeking relief on the two grounds. As per your lordship already knows, as per section 138 of negotiable instrument act, your lordship, legal notice has to be received by the accused, your lordship. Here in this case, your lordship, it was not served, unserved, your lordship. Lordship kindly peruse your
No, at what stage it is pending?
witness examination.
You have appeared there. You take this plea before the trial court.
But
this may not be a ground for quashing.
and also another ground, your lordship, also your lordship. Lordship kindly peruse on there is an agreement on the basis of which, your lordship, it is alleged that the money has been provided, but That agreement kindly correct, Your Lordship. And
No, these are on merits. This, you can take this plea before the trial court.
on the basis of same ground, Your Lordship, I present another criminal petition, Your Lordship. And in that case, Your Lordship, record was fault and the notice has been issued. So I'm praying for issuance of notice, Your Lordship.
This is,
At this stage, notice kindly. This is the order. Your
no. Unless you satisfy this court that to invoke the jurisdiction, inherent jurisdiction, you make out a case.
The criminal petition, complaint petition may kindly correct, Your Lordship.
You can take all these pleas before the trial court.
But as per the section, Your Lordship, 138, receipt of the legal notice is a prerequisite for filing of the NI case. Your Lordship.
Okay.
But that.
Heard, Mr. What is your name?
Camera, Your.
Heard, Mr. K. Mira, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioner, namely Abdul Malik Bordhuya, praying for quashing the proceedings of NI case number 58/2024, pending before the Court of Learned Chief Judicial Magistrate, Tinisukia. Issue notice to the respondents. Since Learned Additional Public Prosecutor has already appeared for respondent number 1, no formal notice need to be issued against the said respondent. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon the said respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 15th of October. Let also the scanned copy of the trial court records be called for. List accordingly.
May I pray for interim order, Your Lordship?
I will dismiss it if you pray for that.
29.
May it please, Your Lordship. My Lordship, have a look at page, my Lord, 15, my Lord.
29.
It's a charge sheeted case, my Lord. Lordship, have a look at page 15, my Lord.
59.
15, my Lord, 15, annexure 2, my Lord. The forwarding report, my Lord.
Yes.
Lordship will see, my Lord, the name and address of the arrested accused person, my Lord. Nasiruddin, Atikur Rahman, and Salimuddin, my Lord. My Lord, I am for Salimuddin, my Lord. Now, my Lord, this Nasiruddin and Atikur Rahman, they approached this court, my Lord, by way of a bail application, my Lord. Their bails were granted, my Lord. Your Lordship will turn to page 34, my Lord.
34.
34, my Lord. The other two accused, my Lord, Nasiruddin and Atikur Rahman, my Lord.
Yes.
My Lord, they approached this court, my Lord, and their bail was granted, my Lord. On the basis, my Lord, now we have a Lordship, have a look at page 36, my Lord, of the same order, my Lord. Page 36, my Lord, the first paragraph, paragraph 7, my Lord. May I read, my Lord?
Yes.
Having heard the learned counsel for the parties and on perusal of the trial court record, it is not in dispute that notice served to the petitioner under section 50 CRPC as well as arrest memo do not reflect any grounds of arrest at the time of arrest of the petitioner. As it appears, the judgment is not delivered by the and subsequently, my Lord, bail was granted, my Lord. And same footing, my Lord. Here, your Lordship will find the notices at page 31 and 32, my Lord. 31 is the 50 CRPC notice, my Lord, which does not reflect any grounds of arrest, my Lord. And the next page, my Lord, 32, my Lord, it's a 50A notice, my Lord. There also, my Lord,
do not reflect any grounds of arrest.
Since when you are behind?
My lord, I am behind the bar, my lord, from 17/06/24, my lord.
And what stage?
My lord, 4 witnesses have been examined, my lord.
Out of?
My lord, I think 10, my lord. The charge sheet is not available with me, and the scan copy, my lord, is completely
How
blank.
many petitioners are there? How many accused persons are there?
3, my lord. Other 2 are out of jail, my lord. Only I am behind the bar.
Heard anything? Okay. Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 BNSS has been filed by the petitioner, namely Salim Uddin, who has been detained behind the bars since 16/6/2024 in connection with Boko, in connection with NDPS case number 80/2024 pending before the court of learned Session Judge Kamrup Amingao under section 21C/29 of the NDPS Act. The gist of accusation in this case is that on 17/6/2024, one Rewat Saikia, SIF police had lodged an FIR before the officer in charge. No, where is the FIR?
Page 13, my lord.
On 16/6/2024, one P. Rajkwa, पहले वाला काट दीजिए. One P. Rajkwa, learned, SIF police had lodged an FIR before the officer in charge of Boko police station, inter alia, alleging that an information was received through reliable sources that the petitioner namely Nasir, you are Nasiruddin.
I am Salimuddin, my lord.
And that one Nasiruddin, alias Nasir Bhai, who is a known narcotic peddler, would be carrying prohibited narcotic drugs in a Maruti vehicle bearing registration number AS01 FW3878. So accordingly, a police team was constituted and a Naka checking was arranged in front of Boko police station. So during Naka checking, the one vehicle bearing number AS01FQ 3128 was intercepted and stopped. During search of the said vehicle, 339 grams of suspected what?
Heroin.
Suspected heroin was recovered therefrom, which were kept in 30 soap boxes. On receipt of the said FIR, Boko PS case number 272/2024 was registered and investigation was initiated. After completion of the investigation, charge sheet was laid
On 2/10/24.
on 2/10/2024 against the present petitioner and two others under section 21C/29 of the NDPS Act. Learned counsel for the petitioner has submitted that the petitioner has been languishing behind the bars since the date of his arrest on 17/6/2024, and only 4 out of listed 10 prosecution witnesses have been examined till date. He submits that in this case, 2 other co-accused persons, namely Nasiruddin and Atikur Rahman, were already allowed to go on bail on the ground of violation of their fundamental rights under Article 22 within bracket 1 of the Constitution of India. The learned counsel for the petitioner submits that the petitioner has also approached this court seeking bail on the ground that no grounds of arrest was communicated to him at the time of his arrest, and therefore his fundamental rights guaranteed under Article 22(1) of the Constitution of India has been violated in this case. He further submits that in view of the judgment of the Apex Court in the case of Vihan Kumar versus State of Haryana, reported in 2025 SCC Online SC 269, such infringement of constitutional mandate of communicating grounds of arrest as soon as an arrestee is arrested would render the arrest of such an arrestee itself illegal, and on that ground and on that count, such an arrestee may be allowed to go on bail. He submits that in the instant case, though notice under section 50 of CRPC was served on him on 17/6/2024, however, said notice do not contain anything apart from said notice does not contain anything apart from the police station case number and penal provisions involved in the case. He further submits that the basic facts which necessitated the arrest of the petitioner were also not mentioned in the said notice, and therefore, in terms of the observation of the Apex Court in Vihan Kumar versus State of Haryana Supra, he is entitled to get bail in this case. On the other hand, learned additional public prosecutor submitted that the quantity of contraband involved in this case is of commercial quantity, and therefore the embargo of section 37 of the NDPS Act is applicable to this case. However, he fairly submits that in the notice under section 50 of CRPC, which was served on the petitioner, a copy of which is available in the records, no basic facts which necessitated his arrest have been mentioned therein. Stop. I have considered the submissions made by learned counsel for both sides. It appears that as the notice which was served on the petitioner at the time of his arrest under section 50 of the CRPC does not contain any grounds of arrest. Neither it mentions about the basic facts which necessitated his arrest in the above noted case, there has been a clear violation of the constitutional mandate under Article 22(1) of the Constitution of India, as well as Section 50 of the Code of, as well as under Section 47 of the BNSS. Stop. The infringement of fundamental rights of the petitioner guaranteed to him under Article 22(1) of the Constitution of India has rendered his arrest illegal in terms of the observation made by the Apex Court in the case of Vihan Kumar versus State of Haryana. And therefore, on that count, the petitioner is entitled to get paid. In view of above submissions, the petitioner, above named petitioner is allowed to go on bail of rupees 1 lakh with 2 sureties of like amount with certain conditions mentioned. This bail application is accordingly disposed.
I'm applying. Declare. Item 30. Here also charge sheet has been pending.
Charge sheet has been laid.
Yes.
You approach the trial court POXO case. Heard Mr. P.P. Bora, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Mr. What is your name?
S.K. Chakma.
S.K. Chakma, appearing for respondent number 2. Learned additional public prosecutor has submitted that though the case diary was called for, however, in the meanwhile, charge sheet has already been laid, and therefore, charge sheet has already been laid, bearing charge sheet number
289/25 dated 2/7/25.
So, in view of the fact that charge sheet has been submitted in this case, this bail application is disposed of with an observation that the petitioner may approach the trial court and may file regular application before the said court for regular bail, if so advised.
Item 32. Regarding notice, we have to take instruction.
Notice upon the respondent number 2, POXO also.
It is not served.
They are supposed to take instruction.
As per the office, not served.
When you will take it?
Also next week, anyway.
Heard Mr. N. Hassan, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. The office note. You have taken steps or not? You have not taken.
I have taken steps.
But
through
it shows that you have not taken steps.
But earlier office note, Lordship may kindly see. They are supposed to take instruction also. Learned PP Lordship.
No, you were directed to take fresh steps on 1/9 because earlier notice was sent to Dumduma instead of Mikir Bheta at Morigaon.
Lordship.
So last order has directed you to take fresh steps, but you have not taken steps. You take steps.
For the office of the learned PP.
Yes. It appears from the office note dated 4/9/2025 that the petitioner has not taken steps for issuance of notice upon respondent number 2, as was directed by this court by its order dated 1/9/2025. Stop. Learned counsel for the petitioner has submitted that he may be allowed to take fresh steps upon respondent number 2, the prayer is allowed. The petitioner shall take steps for service of notice upon respondent number 2 in pursuant to the prevailing notification of the registry in this regard within 3 days. Within 3 days from the date of this order, returnable on, yes, 15th October.
15th,
October,
would it be before that, Lordship? Almost 1 year, Lordship. Yes.
25th September.
True, Lordship, that Mikir Beta PS, because the case pertains to Dumduma PS. Again, it may go to Dumduma.
Okay, now you have to take steps where the respondent number 2 resides.
On last occasion, I took steps on that address,
Mikir Bheta.
but inadvertently it went to.
Now there is an order in the last.
PCR is there also.
Okay, but take steps for
43.
Your Lordship, CD has not been received.
My lord,
CD has not been.
Entire quantity is on today, my lord, 47 days.
Now, what is the contraband?
Suspected heroin of 130 grams.
Oh, it is a, though intermediate, but it is substantial quantity. When can you produce the case diary?
Next week.
Heard Mr. M.R. Khandekar, learned counsel for the petitioner. Also heard Mr. K. P. Sharma, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this matter be listed on 18th of September.
15 only.
18th. Let it be on.
16.
You have difficulty on 18.
Then 16, my lord.
No, do you have difficulty on 18?
I am praying 16 instead of 15. 16.
Okay,
16.
16th of October.
I'm
34, 35 and 36. Let clear. I am for item 36. Out of the same case, 3 cases are there.
So we should take, which one should we take? 36 first.
36 losses. I mean, 34 is understandable.
Yes.
The gist of the allegation is that at the Tata Semiconductor unit, these accused persons have issued some fake job orders, collected money and issued some appointment letters, and subsequently those were detected to be fake.
Yes, there is there.
Charge
Charge sheet
sheet already there. After charge sheet, you have applied before the learned trial court. I have annexed these copies, Lordship.
Why the
I
prayer
am
was
behind the bar for
rejected?
94 days, Lordship.
Why the prayer was rejected by the trial court?
Offences are only magistrate travel 120, sorry, 61, 318, 336, 356. Learned trial court has granted given the region only.
Where is the page
At
number?
page 21. The PP, on the other hand, vehemently objected bail petition on the ground of filing charge sheet automatically absolves the right of the accused persons on gate bail. Additionally, subject offence committed by the accused persons are serious in nature, involving public morality, and during investigation sufficient incriminating evidence have been found against the accused persons, showing their involvement in a big conspiracy to providing job by taking money. As regards the plea, so another plea they will take out. Considering the submissions made by the learned counsel of both the sides, in view of the discussion made above, I have the opinion that submissions made by the learned PP is genuine. Only on that ground, also. At the date of order, I was on the 64th day of custody. This was on 12/8. Another accused in A5 shown as abscond, Lordship. He is mentioned at page 30, 31. I have annexed the charge sheet, Lordship.
Now what is your submission?
Appearance of the accused abscond. Someone has been issued.
No, what is your submission? Why you should be granted bail?
Because it is only wasted travel, Lordship. No one can assure that trial will begin at any recent immediately. No certainty, then someone, then warrant, either to abscond declaring
So no possibility of immediate trial, Lordship. And this is a nested travels case.
And what is your
We are a 24-year-old boy, Lordship.
stand on the accusation made against you?
We are simply denying it, Lordship. We are ready to cooperate any further investigation if required, Lordship.
Yes.
The period of detention is there, Lordship.
Page 17.
Any other submission by or on the same line? Your cases are same case.
Same,
Eh,
more or less it's same.
eh,
Allegations mostly are of forgery and cheating.
Any additional submission?
Additions?
But both the petitioners, my lord, they were arrested on 5/6/2025. One was arrested on 5/6/2025, and the other was arrested on 6/6/2025.
How many days?
96 days, my lord. 96 days, my lord. Now,
Okay.
my lord, the thing is that the accusations are mostly of a documentary nature, my lord. Some allegedly some fake joining letters, some fake appointment letters were issued, my lord, and all of such documents have been seized. The bank accounts of the petitioners have also been frozen, my lord. The statements have been recorded of all the witnesses. So since the charge sheet has been completed, and my lord, at this stage, the the start of the trial, it cannot be said that it will start at an early date because one of the accused is still absconding, man.
Okay. What are the punishments?
Punishments are, my lord, all sentenced with imprisonment up to 7 years, man.
Maximum.
Maximum is 7 years, man. Now, at this stage, my lord, we kindly see whether, my lord, the further the custody of the petitioners are necessary for a fair trial or not.
Okay.
Now, in this regard, the one aspect which Lordship will examine as to whether they, my lord, can hamper or tamper with the prosecution evidence. In this regard, my lord, my humble opinion is that the presumption that an accused is innocent will also include a presumption that he will not hamper or tamper with the prosecution evidence. And unless and until some extraordinary materials are produced by the prosecution that he will tamper or he will interfere with the witnesses. Otherwise, my lord, it cannot be, at this stage, cannot be said that, my lord, their further custody is required only on that ground.
And what is the assurance that you will cooperate you will not abscond
That
like?
is open to them because tomorrow, my lord, if there are any materials that I have interfered with the prosecution evidence, they can always move an application for cancellation of bail. For such offences, my lord, Lords will see the gravity of the offence, my lord. The sentence, the maximum sentence that can be imposed if the petitioners are convicted, my lord.
Okay.
So I'm not going to submit on merit, my lord.
Okay. Yes,
They are
Mr. Sharma.
ready to appear for and contest the trial, man. They are ready to face the trial.
Yes, Mr. Sharma. You same or anything else?
Petitioner in item number 34 is a 22-year-old student, my lord, in search of a job, my lord. He was one of the persons, my lord, who had applied for the job, my lord, and somehow he also got involved in the whole incident. No criminal antecedents, my lord, and his age, my lord. The lordship will consider that as a mitigating factor. He is in custody for 96 days, my lord. 96 days, 22-year-old person, my lord, and no criminal antecedents, my lord. Rest, I adopt the submissions of my learned colleagues.
The accusation against you is that?
Against me is that, my lord, I was part of that WhatsApp group, my lord. Telegram group, my lord. Sorry, WhatsApp group, my lord. Where these informations pertaining to this, my lord, were disseminated. That regarding this job, my lord.
Okay. Yes.
Lordship is taking up item 36.
Last one first.
Yes, 36. 36, Lordship will kindly come to page 17.
Yes.
This is the forwarding, Lordship. Lordship will kindly come to the grounds reason of arrest. Point number 2. During investigation, the laptop of Syed Tarifullah Ahmed was duly seized from his possession and found all forged calling letter, appointment letter of PSAT available there, which were sent to WhatsApp group. He, along with other co-accused persons, created said WhatsApp group in which he was admin to the group, and they were providing job advertisement and appointment letters to employee in Tata Semiconductor plant, Jagirot, to other members of the group. The below noted accused person has been found to be a part of a group engaged in fraudulent practices, promising employment opportunities at so and so. And 5, Lordship, you can see fake interview call letters, appointment letters bearing false company details have been found at the gates of so and so, which were allegedly issued by the accused. And so this is the primary allegation against the present petition, Lordship. 36. And regarding Lordship, item 35. There are two petitioners before your Lordship. One is Saiful Islam and the other is Tufail Ahmed. Saiful Islam, that is petitioner number 1. He is the brother-in-law of petitioner number 2.
Okay.
Lordship, an interview was conducted at a hotel in Morigaon, where all those persons were asked to come and give interview regarding the appointment. All this was done, Lordship. This was all fake, Lordship. And Lordship, the candidates, a WhatsApp.
These petitioners were the members of WhatsApp
Yes.
group.
No, Lordship, they were present, Lordship. They are the one who orchestrated the whole thing, Lordship.
Okay.
All these persons, Lordship. So, Lordship, just to submit the modus operandi, Lordship. WhatsApp group was formed in which interested candidates were asked to join, and then they were money was taken from them, and then Lordship, fake appointment letter and all this was issued to them, Lordship. And Lordship, Saiful Islam, in item 35, he collected large amount of money, Lordship. Large scale false recruitment scheme was conducted. And Lordship, one of the co-accused, who happens to be Arif Muhammad Baharul Islam, he is absconding, Lordship. And he happens to be the father of item 34, petitioner in item 34.
Okay, now
The absconding accused, who is absconding, Lordship, he happens to be the father of petitioner in item 34. Now, Lordship, the cognizance was taken on 5/8/25. Cognizance was taken, and the next date was fixed on 2/9/25. So it was fixed on 2/9/25 as per the records, Lordship. It is fixed at appearance dates, at this stage, Lordship. Now, Lordship, there are some statements, Lordship, 180 statements of a person who happens to be the owner of a DTP center or Xerox centers, where those appointment letters were printed, Lordship. His statement is also available apart from other candidates, Lordship. Their statements are also there. And Lordship, this Tarifullah Ahmed, who happens to be the petitioner in 36, Lordship, item 36, petitioner, Lordship. He created the group, Lordship, Tata Candidate Group.
okay. Now,
Yes.
why are you opposing?
Opposing, Lordship, because to say, Lordship, that the trial with not comments will be a premature submission at this stage, Lordship. Because already cognizance has been taken on 5/8/25 and it is fixed for appearance, Lordship. And in the meantime, Lordship, a prayer has been made for issuance of warrant of arrest, Lordship, against the absconding accused. So, Lordship, to hold at this stage that the trial with not comments, Lordship, will be a premature, Lordship, at this stage. And Lordship, at least let the charges be framed at this stage, Lordship. If they have anything to say, they can submit at this stage of charge framing, Lordship. And in respect of, Lordship, the witnesses, there are number of witnesses, young boys, Lordship, from whom money was taken, Lordship, and their statements are yet to be
examined, Lordship. So at this stage, Lordship, it is premature, Lordship.
The statement means during the trial.
Evidences, Lordship, that will have a direct bearing on the trial of the case, Lordship. Because all these persons, Lordship, the WhatsApp group, it contains a number of persons who were young candidates, Lordship. They were lured into those scam, Lordship, and money was taken. And all these petitioners are involved in this case, Lordship. On merits, Lordship, they do not have a ground. And if Lordship permits me, just Lordship will find the charge sheet at page. It starts at.
No, assuming that there are materials.
Yes.
Justifying framing of charges against them. Then, though as the punishment is 7 years,
Lordship.
why should they be detained? There may be ground that they may abscond,
Lordship.
they may threaten witnesses. Only on those grounds.
Only on those grounds, Lordship, and Lordship, the court below has observed in the rejection order. As has been showed, Lordship.
Nature of.
Yes, nature of the accusation, Lordship, and also, Lordship, the offense, Lordship, that was committed in a pre-planned manner, Lordship. So that has to be taken into consideration by your Lordship.
Okay.
And for this conduction of, Lordship, the fair trial, Lordship, at this stage, Lordship, their trial has not yet started, only cognizance has been taken, Lordship.
No, that is one of their ground that trial has not started,
but Lordship,
and it may not start.
But Lordship, there has been no delay, Lordship. In the month of August itself, cognizance was taken. It has been fixed for appearance, Lordship. Bailable warrant of arrest has already been, prayer has been made for issuance against the absconder, Lordship. And Lordship, so at this stage to hold, Lordship, that the trial will not commence, Lordship, will be premature, Lordship.
No, otherwise the basic question
Lordship.
that they are deemed to be innocent during pendency of the trial. Why they should be detained?
Deemed to be innocent, Lordship, but Lordship will also have to consider the materials, evidences that has been collected so far from the charge sheet, Lordship. And once charge sheet has been filed, Lordship.
But is there any materials on record which would indicate that they may threaten the witnesses?
No.
Or they may abscond?
No, Lordship, the absconding part, Lordship, one of the
co-accused, who is the father?
The close relative of the petitioner.
One of the petitioner.
Yes.
Okay.
So that is a ground.
Okay. In item number 37. 36. Heard Mr. S.K. Poddar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Syed Tarifullah Ahmed, who has been detained behind the bars since 7/6/2025, within bracket, for last 94 days, bracket close, in connection with PRC case number 694/2025, corresponding to Jagi Road PS case number 126/2025, under section 318 within bracket 4/336 within bracket 3/356 within bracket 2/61 within bracket 2 of BNS 2023. The gist of accusation in this case is that on 3/6/2025, one Arup Jyoti Sharma had lodged an FIR before the officer in charge of which police station? Moregaon Police Station, Jagi Road Police Station, inter alia, alleging that though the Tata Projects Limited, TSAT, Moregaon, had not published any advertisement anywhere for recruitment drive in their ongoing project at TSAT Jagi Road. However, the informant had received an information that once Saiful Islam Ali, that is the Saiful Ali of Nagaon, and some of his associates have collected huge amount of money in the name of offering employment at TSAT project. Stop. It is also alleged that some fake interviews and appointment letters were also issued by them. Stop. Learned counsel for the petitioner has submitted that the petitioner is innocent and is a young boy of how much age? Age of 24 years of age. He submits that in this case, the investigation has been completed and charge sheet has already been laid. And one of the charge sheeted co-accused person within bracket A5 has been shown as an absconder in the charge sheet. He further submits that petitioner is languishing behind the bars since for last 94 days, and there is a unlikelihood of even commencement of the trial due to the fact that one of the co-accused is absconding and is yet to appear before the trial court. Stop. He further submits that all the offences involved in this case do not entail punishment of imprisonment for more than 7 years. And the petitioner is ready to cooperate in trial. Hence, he submits that considering the long detention of the petitioner and considering the fact that the petitioner is ready to cooperate in trial, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has opposed the grant of bail to the present petitioner. He submits that the petitioner, along with the other co-accused persons, has been found to be involved in issuing forged call letter and appointment letters to innocent persons who were duped to pay money against assurance of getting appointment in TSAT's Jagi Road. He further submits that considering the nature of accusation in this case, the trial court has rejected their bail application. and same has been correctly done. He also submits that the trial court has also issued non-bailable warrant.
Prayer has been made, Lordship. It is not clear. Lordship.
A prayer has been also made before the trial court by the prosecuting agency to issue non-bailable warrant of arrest against the accused number A5, who has been shown as an absconder in this case.
Lordship, this charge sheet was filed on 31/7/25. After that, cognizance was taken on 5/8/25. So
He also submits that the trial is at a very initial stage, and even appearance of the all accused persons are they have not yet been completed. Hence, he submits that if the petitioner is allowed to go on bail at this stage, it may impede fair trial. It may hamper the fair trial. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available in the records. Stop. On perusal of the charge sheet, it appears that the offenses under which the charge sheet has been laid against the present petitioner as well as against the co-accused persons do not entail punishment of imprisonment for more than 7 years. Stop. It also appears that the relevant documents and materials have been seized by the investigating officer during investigation, and the investigation has completed. It also appears that there is no material on record which would suggest that the petitioner may abscond or may evade the course of justice. There is also no material on record to suggest that they may involve in threatening or influencing the witnesses. As such, stop considering the fact that charge sheet has already been laid in this case, as well as considering the period of detention undergone by the petitioner. This court is inclined to grant bail to the petitioner. Accordingly, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the learned trial court with following conditions, trial conditions. This bail application is accordingly disposed of. Next, item number on same line, some changes will be there that I will dictate. Same ground. 34, 35, 36.
38. Lordship, there is a office note, Lordship. Pen copy has not been received.
Not heard, Mr. What is your name? Heard Mr. S. Hussain, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Office note dated 4/9/2025 shows that the scanned copy of the trial court records have not yet been received. Stop. Issue reminder for the same. Let the, what is the case? NDPS case? 302. Let the, no. Okay, how can you say? We will believe to whom?
I have inquired about this to the participant already
Okay.
received. This is not. there.
Date at 18th. Let this case be listed on 18th.
39. Here also, Lordship, one office notice there. Maybe. Scan copy of my trial court refers to a confirm. And read to the informant was not received probably. He issued my lord. Scan to.
This is a POXO case.
Yes.
You have taken steps for
Hello, I have taken.
notices also, there is no service report. You take that information also. Heard Mr. J. Islam, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Office note dated 4/9/2025 shows that the scanned copy of the trial court records have not yet been received. Neither the service report of the notices issued to respondent number 2 has been received. Stop. Issue reminder for the same. Issue reminder for the trial court, scanned copy of the trial court report. Stop. Learned additional public prosecutor is requested to take information regarding fate of the notice issued to respondent number 2 from the officer in charge of jurisdictional police station and let this court know about the same on the next date fix. List this matter on 22nd September.
Also, may I know when, on what day they took steps?
They took steps on
28.
1/9.
That is my lord. 1/9 lordship, it won't come lordship. If they have taken steps on 1/9 lordship, it takes time lordship.
Okay, let us see. On, come on, 22nd September.
Right.
Hello, this is a regular bail petition, mother. Here we have challenged on the ground of mother not complying with the violation of Article 22 of the Constitution of India. mother.
What is the offense?
Offense for NDPS case, fifth, section 17. My lord, here, my lord, your lordship may kindly see, this is a covered case, covered by Vihan Kumar's case. Your lordship may kindly see the, kindly see the notice I've annexed.
But this is a NDPS case. In
Here,
the,
nothing has been recovered from his possession.
in the case diary,
Already called for lordship along with the FSL report. sir.
let them produce the case diary.
Is under section 47. In the notice, is under section 48 also, there is, my lord, it is written in English, there is no vernacular, my lord. As per Vihan Kumar's case, my lord, it should be in a language written in the language the petitioner, the person understands. So, and in the, there is discrepancy in the arrest memo also, my lord. There's violation of the statutory provision in the arrest memo. also.
How much was the contraband?
18 packets of jelly-like substance suspected to be opium, 18 kg, my lord,
Let
18.108.
them produce the case diary. Heard Miss S.V. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. When?
From Karbi Anglong lordship.
Suggested.
Yes.
Let this case be listed again on 18th of September.
41.
Please, your lordship. Lordship, kindly maternally pass over for timing.
Why?
Should my see appear?
CD is there.
Yes, yes, CD available.
Okay. We'll take it after something.
Item 42.
Maybe the lordship. Lordship, regular bail application, lordship, the petitioner is behind the bar for last 89 days. And his second bail application, lordship.
What is the offense?
Offense, lordship, under section 409 and 420 IPC, lordship.
It is there.
Yes, it is there. Lordship will remember this case earlier rejected, the person who absconded from Guwahati and he was been arrested from UP, Lordship. Regarding the bank loan, he took loan, Lordship. Thereafter, he left.
Okay, he started business.
Yes,
by a new name.
He was brought from Meerut.
So this is that case, Lordship.
No, whether investigation, only one day is there.
CD is available, Lordship. So he may be allowed to go, Lordship, with some strict condition, Lordship.
Okay. Heard Mr. N. Hassan, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Anand Rasivasia, who has been detained behind the bars since 12/6/2024 within bracket for last 89 days in connection with Tinsukia PS case number 156/2020 under section 420/409 of Indian Penal Code. Stop. The gist of accusation, Code para 3 from page 30. Stop. Learned counsel for the petitioner has submitted that before approaching this court, this time, the petitioner had earlier approached this court for bail also. And on that occasion, his prayer for bail was rejected on 1/8/2025 in bail application number 2190/2025. He submits that this time the petitioner has approached mainly on the ground of period of detention undergone. He submits that the offenses involved in this case, the maximum period of detention under section 487 of BNSS, for which the petitioner may be kept behind the bars, is 90 days. And he has already completed 89 days. And on that ground only, he seeks his bail. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Tinsukia PS case number 156/2020 and has submitted that there are sufficient incriminating material against the petitioner in the case diary. However, he also submits that the case has been fairly progressed.
It has not been filed.
And like charge sheet has not yet been filed. Stop. I have considered the submissions made by learned counsel for both sides. Stop. Considering the fact that the investigation has fairly progressed, as well as the period of detention undergone by the petitioner, the petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the learned trial court. Learned trial court with one surety of like amount, who should be the resident of the state of Assam, with following conditions, number 1 and number 2. This bail application is accordingly disposed. Trial conditions.
Obliged.
Am I allowed to withdraw this?
What is your name?
M. Alam Lordship.
Art Mr. M. Alam, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw this instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal. Yes.
I would be allowed to withdraw the lordship.
Art Mr. U.K. Burman, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
My lord, the implication is part of hearing is going on. Otherwise, my lord, the last order has been communicated to the Commissioner of Police, my lord, and subsequently an inquiry has been ordered. But the inquiry report not yet, my lord, he has taken instruction, the inquiry report is not yet completed. Because of that, my lord, no report is given today, my lord.
When can you produce that?
15 days time is required, my lord. Otherwise, my lord,
Where inquiry is going on?
by the Commissioner of Police, he has directed, my lord.
Okay.
How it was done, whether
Yes. You have to submit the inquiry report to this court also.
my lord.
Inquiry was not directed by the court.
Not directed, but
Because
they themselves.
Police, okay. Heard Mr. D.K. Nath, learned counsel for the petitioner, also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that
In the
that it has been informed to the learned additional public prosecutor that regarding the unavailability of women police station case number, the unavailability of the records of women police station case number 163/2019 in the all women police station, and inquiry has been initiated by the
Commissioner of Police, my lord.
by the Commissioner of Police, Guwahati. He also submits that the inquiry would take at least 15 more days. He would be able to submit the inquiry report before this court also. Considering the submissions made by learned counsel for the learned additional public prosecutor, let this case be listed after 15 days. After reopening, after reopening, let this case be listed on 16th of October, on which the inquiry report of the inquiry conducted as per orders of the Commissioner of Police will be produced before this court by learned additional public prosecutor.
Might be the word without fail, because 4 or 5 times.
No, let us,
That
no,
was-
we have not ordered inquiry.
That is correct.
Let us see, otherwise some other, suppose it is not found,
Then, my lord.
then what is your submission?
Well, actually,
You come prepared with the submission, assuming that records are not found at all. Then what course this court should take? On that, you have to make submissions.
I hope, my lord, because the matter is very sensible for the informant. So I hope that the record is found accordingly.
No, you come court with preparation, being totally hopeless. Don't have any hope. You come with that preparation. If it is found, it is good. If it is not found, then you make your submission, list accordingly.
Well,
Item number 41.
So,
Item 63 from supplementary list.
so,
Item 64.
Item 64 after some days, my senior selection other court, can be disposed of. He wants to appear, after
what is the matter?
Lordship,
Take
there,
appointment, madam.
this is in relation to Lordship will find the FIR at page 12.
So she may take up this matter after 5 minutes, madam. My senior, he was about to appear, madam.
He has nothing to worry about. I will
Still,
submit this favor.
You will favor him.
Yes. He has been in custody since Lordship 19/7/25 and today is around Lordship 54 days Lordship. And offense are Lordship of 60 days offense Lordship.
After 5 minutes, I will.
No. Why after 5 minutes?
I don't have the brain, madam. We will do it my senior.
We don't require your assistance. If
Fine.
you are
And Lordship will find it was
heard Mr. D. Bora, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Shashanka Das, alias Sushanko Das, who has been detained behind the bars in connection with
Nolbari PS case 223.
Norbury PS case number 220. What is the PA? 223/2025. Since 18/7/2025, within bracket for last 53 days, in connection with since last 53 days. The gist of accusation in this case is that where is the affair?
Page 17. Lordship, fake appointment letters, Lordship. In the Divisional Forest Office, Siran Division. Lordship will find it at page 20 in a better format, forwarding.
Page
20, the forwarding Lordship will find.
Gist of accusation in this case is that on 16/5/2025, one Shri Kunjan Basumatari, DCF, Divisional Forest Officer, Sirang Division, had lodged an FIR before the officer in charge of Kajalgaon Police Station, inter alia, alleging that on 15/5/2025, about 18 persons appeared before the Divisional Forest Officer office and produced their appointment letter, which were found to be fake. Stop. On coming to know about the issuance of fake appointment letter, an inquiry was initiated. During preliminary inquiry, it came to light that the present petitioner is involved in the racket of issuance of fake appointment letter. Learned counsel for the petitioner submits that for the offense alleged in this case, the petitioner may be detained behind the bars, during investigation, under section 487 of BNSS, for a maximum period of 60 days only. And he has already completed 53 days behind the bars. He submits that considering the period of detention undergone, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Nalbari PS case number 223/2025. What is the progress? Failed. And has submitted that the investigation has fairly progressed in this case. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary of Nalbari PS case number 223/2025. Stop. Considering the period of detention undergone by the petitioner within bracket 53 days, bracket close, as well as the progress made in the investigation, this court is of considered opinion that further custodial detention of the petitioner may not be necessary for fair completion of the investigation, if he cooperates in the investigation. Stop. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Nalbari, with following conditions. 1 and 2. Send back the case diary. This bail application is accordingly disposed.
Your Lordship, on further inquiry, it was found that the place of occurrence is on Nalbari, and therefore the case was transferred to Nalbari.
Okay. Otherwise, where it was registered?
Kachalgaon.
Oh. So therefore, Nalbari CJM.
Yes.
Ably obvious now.
Still 43.
Wait, please. It's an anticipatory bail application pending since last year, madam. I am otherwise on interim, madam. And I have also appeared before the ILO.
You have appeared before I.
He has appeared before his statement also recorded. However, in his possession, this petroleum products were found.
Okay. Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. A.K. Das, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was granted interim bail by this court on which date?
9/1/25, madam.
On 9/1/2025. And in pursuant to the directions of this court, he has appeared before the investigating officer and has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of which police?
Roha PS case number 136.
Roha PS case number 137.
36 of 2026.
136 of 2024, and has submitted that though there are some incriminating materials against the petitioner in the case diary, however, he has appeared before the investigating officer and his statement under section 180 of BNS has also been recorded. Stop. Since no, stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary. Since it appears that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim bail granted to him on 9/1/2025 is hereby made absolute, with the condition that we shall continue to cooperate in the investigation. Send back the case diary. This bail
44.
None has appeared for the petitioner on call. Let this case be listed in the next week on a date to be fixed by register. CD is there?
44.
Learned, learned additional public
Not
prosecutor submits that case diary is not available. Hence he prays for some time for production of the case diary. Prayer is allowed.
Item 45.
May I please your lordship?
Charge submitted, Lordship.
Sheet submitted.
My lordship, I was on interim since March 2025. I have appeared.
Heard Miss S.G. Borua, learned counsel for the petitioner, who submits that record to court, who submits that the petitioner was allowed to go on interim bail by order dated
27/3/2025, my
and in pursuant to the directions of this court, he has appeared before the investigating officer and has cooperated in the investigation. On the other hand, learned additional public prosecutor has submitted that in this case, charge sheet has been laid bearing charge sheet number
89/25 dated 30/03/2025.
Stop. As the petitioner has cooperated in the investigation and as the charge sheet has already been laid, hence this anticipatory bail application is disposed of with an observation that the interim bail granted to the petitioner by order dated
My lordship, 27/3/2025.
27/3/2025 is hereby made absolute, subject to the condition that he shall cooperate in the trial.
Ship must apply.
This bail, anticipatory bail application is accordingly disposed.
My lordship, with due respect, my lordship, 3 petitioners, my lordship.
Instead of petitioner, petitioners.
Item number 44, my lord. It is stated that CD is not there. Actually, CD is available in our office, but in a different code, my lord, code number 22, one matter has come. CD was sent to that code, my lord. So maybe
On the
already-
next day,
already that is fixed
we have given a date, no, next week.
next week, my lord.
It is not available. Release this matter. When? Next week at the date, on 18th.
Item 47.
May I please your lordship? Lordship, in this matter also petitioner was granted interim on 21/4/2025, and as per the interim order, I have cooperated with the investigation, my lordship.
Heard Ms. S.G. Borua,
Charge sheet submitted.
learned counsel for the petitioner. How many petitioners?
My lordship, 1 petitioner.
Petitioner, also heard Mr. K.K. Das, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was granted interim bail by order dated
My lordship, on 21/4/2025.
25. And in pursuant to the directions of this court, he has appeared before the investigating officer and has cooperated in the investigation. On the other hand, learned additional public prosecutors has submitted that the charge sheet has been laid in this case bearing charge sheet number
69/25 dated 24/04/2025.
in view of the fact that charge sheet has been submitted, as well as considering the fact that the petitioner has complied with the directions of this court, the interim bail granted to the petitioner by this court on 21/4/2025 is hereby made absolute with a condition that he shall cooperate in the trial.
Must oblige, my lordship, highly oblige.
Item 48.
This matter is again listed before your lordship after Honorable Chief Justice order on administrative side. Because of that notification, which says lordship that if it is withdrawn, then that has to be listed. And on the other hand, that Honorable Justice Mr. P.J. is sitting in civil bench.
Yes.
So this is the
No, but against you, there were some materials, I think.
So here, my only submission before your lordship is that
Co-accused.
Zakir Hussain and my allegations are same. That cannot be distinguished. And when one of the accused is granted bail on the same facts and circumstances, then I cannot be denied of that. That is my humble submission.
As
And
my lord
because of
not
that,
convinced, but because of that, my lord has pointed out in the last occasion, 1/9/2020, that order. Otherwise, my lord, that order has been passed by that honorable court, my lord, without perusing the CD, my lord, and all this, my lord. But now, in this case, my lord, 3 times search was made on 10/11/24, 19/11/24, 20/11/24. He was not found. And in the LCR, my lord, I have trademarked. Otherwise, materials are there, but that was allowed. That's another thing, my lord.
In criminal cases, the question of bail is decided on the facts of each case.
that is there. But if your lordship see the judgment which I have placed before lordship on the other day,
What is the judgment?
first is lordship that Kerala High Court judgment, Manikandan and
No, which judgment you are relying?
I have given some
Yep. Judgments. Judgments बेलक के रखेंगे. Nine.
in that case, I am just sending over my copy. Paragraphs are marked here. Can you see those paragraphs? There, all high courts and Supreme Court say if there is no distinguishing feature in two cases, then that benefit has to be extended.
Where you read.
That's it.
Read the judgment which you are pressing.
I'm placing all the cases. All are on same paragraph.
Is there any apex court judgment?
That's it.
Apex court judgment.
Apex court judgment is also
You
there.
place that.
That may I read or should I place it?
Yes.
Paragraph 3
No,
and
you read that portion.
Paragraph 3 and 7 I am reading also. The learned counsel for the respondent state vehemently opposed the petition. He submits that the petitioner is a part of conspiracy heads to eliminate the disease. He submits that the circumstances as discussed by the learned single judge of the High Court clearly point out the finger towards the present petitioner. Then after, then Lordship, I am skipping the other parts. Paragraph 7, Lordship. Upon perusal of the charge sheet as well as the impugn order, it cannot be said that the role of the petitioner herein stands on a higher pedestal than that of the co-accused investigation unrevealing change circumstances. This aspect also requires to be taken into consideration. And in such circumstances, the principle of parity as an universal application or a straitjacket formula cannot be applied. So from this judgment, what I have understood, Lordship, is that if there are circumstances which shows that there are distinction between those accused person, then only that benefit may be refused. But if
Okay. What was the accusation against you?
in FIR, there is no specific allegation against
Charge sheet?
In charge sheet also, there is nothing. But from the record, what I find, Lordship, in the some of the witnesses say that these two persons hit the accused with a baton on the head. And some witnesses say that this present petitioner stabbed with knife the victim. But that knife injury is not there in the postmortem report. Only one head injury is there.
Witness, I have flag mark management Perus. Petitioner is Kalu Mullah. Kalu alias Anwar.
Yes. Anything else?
That is the whole information before, Lordship.
What accusation against you is also of using knife?
But that medically do not support that part. No stab injury is there in the body of the victim. That in fact help the present petitioner because there are contradictory versions regarding his involvement.
Yes.
But one thing is that, Malak, yes, Malak, parity in those cases, Malak, if bail is granted, this page 47, 11% is page 48, the co-accused. In that case, Malak, in the motion day itself, Malak, as he want to appear before the court below, that bail is granted without perusing the record, man. Record was not before us when this case was considered. Now record is with us, Malak. In that particular case, when it was considered, only the FIR and maybe the charge sheet, Malak, was there. Only on the motion day, Malak.
Whatever that order was passed, that I am not, this is not an appellate court. If that order they could have challenged or they could have come up for cancellation. When they have not filed any appeal or cancellation, they cannot distinguish, they cannot argue on that point. See, whether it was passed without documents or without record, that they cannot.
I have to,
because I have given one judgment of the Honorable Apex Court bail order also. Your Lordship will find that in that case, the Learned Session Judge granted bail, and that was considered because no appeal was filed against that order.
My duty is to bring the truth, my lord. Whatever may be the materials, my lord, in that point of time, my lord. Obviously, my lord, on record, it was no LCR was.
How many accused are there?
Accused 12 persons are there.
How many have appeared?
All are on bail except the present petitioner. If he appears, then trial will proceed. That is they can Lordship proceed for that.
Yes, Mr. Vishwas, anything?
Well, my submission is that you will find from medical evidence death. There is a question of bottom has come, injury caused by lung bottom. Death following coma as a result of the injury sustained to the head. Described all the injuries were antemortem and caused with blunt force impact. Injury to the scalp is suggestive of homicidal nature. So, my lord, it is apparently the boy who was child, school student child, he was coming, he was suddenly attacked and he was attacked with the bottom. Now, my lord, my learned PP has already placed the materials when the learned single judge considered those bail at that time, those all records were not there. It is so, my lord, you are coming, your lordship is now examining the subsequent record. And my lord, as if my learned friend, bail petitioner, my lord, he is arguing as if he is in the trial court. All these things will come in the trial. Bail is not a matter of trial. He is giving my lord, our humble submission before your lord that let him, your lordship, direct him to appear. learned special session court. Learned session court will consider it according to law. What is the wrong?
Heard, Mr.
Only
A.
one thing, Lordship, that I have argued on merit because, Lordship, I have to place before your Lordship that
Similarity.
whether there are distinguishing feature or not. Only for
But it
the
will not
purpose of
come here.
that,
It will not
I have
applicable
not,
here at this
no,
juncture. It will not be applicable.
to apply merit.
Heard, Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor, as well as Mr. S.C. Vishwas, appearing for the informant. This application under section 482 of BNSS has been filed by the petitioner, namely Alu Mullah alias Anwar Hussain, under section 482 of playing for grant of anticipatory bail in connection with what is the PRC case number? In connection with
417, Lordship.
PRC case number
2025. 24.
417/2024, corresponding to the Manipur PS case number 105/2024 under section 61 within bracket 2/189 within bracket 2/296/75/117 within bracket 2/12/126 within bracket 2/109/103/3 within bracket 5 of BNS, which is presently pending before the Court of Learned Additional Chief Judicial Magistrate. The gist of accusation in this case is that on 23rd of July 2024, one Umar Kaji had lodged an FIR before the officer in charge of Manipur Police Station, naming 12 accused persons therein, including the present petitioners, inter alia, alleging that the accused persons named in the FIR had brutally assaulted the son of the informant, as a result of which he sustained grievous injuries on his person. Stop. After lodging of the FIR, the victim had succumbed to injuries. Learned counsel for the petitioner has submitted that after completion of the investigation, charge sheet has been laid in this case against how many accused persons?
12.
Against 12 accused persons, including the present petitioner. He also submits that all other 11 accused persons are on bail, except the petitioner. He further submits that though in this case charge sheet has been laid, however, as the aforementioned PRC case is pending before the Court of Learned Additional Chief Judicial Magistrate, who, considering the punishment prescribed for one of the offense, that is 103 within bracket 1 of BNS, which prescribes imprisonment for life as well as death as the punishment, may not grant bail to the petitioner if he appears before the committal court due to the embargo in section 480 of BNSS. 480
BNSS.
480 BNSS. Stop. He further submits that the accusation against the petitioner, as appears from the statement of the witnesses recorded during investigation, is that he assaulted the victim along with other accused persons, mainly with accused number 2, Zakir Khan, with a wooden piece. Your accusation is with you only stabbed.
Some witnesses said I used the knife, and some witnesses made general allegation against Zakir and me that we both assaulted the deceased with the wooden baton.
With a wooden piece within bracket bottom. He also submits that though some of the witnesses have also stated in their statement recorded under section 180 BNSS that the present petitioner had also stabbed the victim with a knife. However, he submits that the post-mortem examination report belies the said testimony, as no stab injury was found on the person of the petitioner. He further submits that the co-accused Zakir, who stands exactly on the same footing to that of the present petitioner, was granted anticipatory bail by a coordinate court bench of this court on 4/2/2025 in AB case number 129/2025. And he submits that as the petitioner stands on the same footing, the principle of parity would be applicable, and he may also be granted anticipatory bail like that of Zakir, like that of co-accused Zakir Khan. He submits that in support of his submissions, he has cited the following rulings. Number 1, Suraj Vijay Agarwal versus State of Maharashtra. Stop. State of Maharashtra, within bracket, disposed of by Apex Court on 21/8/2023 in special leave to appeal within bracket criminal number 828432/2023. Number 2, Manika. Number 2, Manikandan NP versus State of Kerala. Stop. Disposed of by High Court of Kerala on 21st January 2025 in bail application number 1129269/2024, as well as number 3, Narayan Swamy versus State of Karnataka, reported in 2017 Criminal Law Journal 3159. Stop. On the other hand, learned additional public prosecutor has submitted that the petitioner is one of the main accused against whom accusation has been made in the case diary. He further submits that the petitioner was evading his arrest during the investigation stage, and it is apparent from the records that on 3 occasions police tried to apprehend him during investigation. However, he evaded the arrest. He also submits that the judgment of the coordinate bench of this court, the order of the coordinate bench of this court in the case of Zakir Khan versus State of Assam, within bracket, order dated 4/2/2025, in case number AB 129/2025, may not be applicable to the in the instant case, as the said order for grant of anticipatory bail was passed in motion stage without perusal of any records. Whereas in the present case, the records are before this court, and which indicates the role played by the petitioner in commission of the alleged offense. Learned counsel for the respondent number 2 has also vehemently objected to grant of anticipatory bail to this case and to the petitioner in this case, and has stated that the petitioner, there are materials to indicate the complicity of the petitioner in commission of the offense, which resulted in the death of the minor son of the present petitioner in this case. He therefore prays for dismissing the bail application. I have considered the submissions made by learned counsel for both sides. Though the accusation leveled against the present petitioner are grave in nature, however, from the materials available on record, it appears that all the other 11 co-accused against whom the charge sheet was laid are on bail, and only the present petitioner has not appeared before the trial court, has not appeared before the committal court, and therefore the case is yet to be committed to the trial court by the committal court staff. It also appears that the accusation against the present petitioner is similar to that of those made against co-accused Zakir Khan, who has already been granted bail by the coordinate bench of this court. The apprehension of the accused, of the petitioner, that on his appearance before the trial court, before the committal court, he may be remanded to custody, is also not without any basis, as the offense, as one of the offense in this case is under section 103 of BNS, which entails punishment up to life imprisonment or death. And therefore, the embargo on a court of London judicial magistrate, within bracket additional chief judicial magistrate, under section 480 of BNSS, in granting bail in such cases where the punishment extend to life imprisonment or death is applicable to this case. Though while considering bail, facts of each case has to be considered for arriving at a decision as to whether bail is to be granted or not. However, if in a case there are more than one accused and facts pertaining to one accused is similar to that of one of the other accused, and if the said accused has been granted bail, this court is of also considered opinion that the principle of parity would be applicable in such cases. Where is that observation?
That Kerala High Court judgment also, that Kerala High Court at Ernakulam. And Supreme Court also observed that part.
Stop. As the trial has not yet commenced, in this case, as the committal of the PRC case number
417 of 24.
417 of W25 24 has not yet been made due to absence of the present petitioner. It is also for the interest of speedy trial that the present petitioner appears before the committal court at the earliest. Considering the above stated facts and circumstances, as well as considering the submissions of London Counsel for the petitioner that the petitioner is ready to help. Also considering the fact that one of the co-accused who was similarly situated has already been granted anticipatory bail by a coordinate bench of this court. This anticipatory bail application is disposed of with a direction to the petitioner. When is the next date fixed?
24/9.
With a direction to the petitioner to appear before the Court of London, Chief Judicial Magistrate Bongaigaon, in PRC case number 417/2024 on the next date fixed before the said court, that is 24/9/2025. Stop. And cooperate in the trial. If he does so on the same day, on the said date, he shall be allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of London Additional Chief Judicial Magistrate Bongaigaon. This anticipatory bail is accordingly disposed of.
Obliged.
Item 49. Petitioner is an interim, he has duly appeared, Lordship, and recorded his statement.
Heard Mr. S. Deka, London. Case diary is there. He appeared. How many petitions? Learned, heard Mr. S. Deka, London. Counsel for the petitioners. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioners has submitted that the petitioners were granted interim bail. Petitioners, namely Jitu Borgohai and Shri Sanjay Gogoi, were granted interim bail by this court
On 11/6/2020.
11/6/2025. And in pursuant to the directions of this court, they have appeared before the investigating officer and have complied with the and have cooperated in the investigation stuff. On the other hand, learned additional public prosecutor has produced the case diary of Tinsukia PS case number 187/2024 and has submitted that the petitioners have appeared before the investigating officer on 14/6/2025. Stop. Considering the fact that the petitioners have complied with the directions of this court and have cooperated in the investigation, the interim bail granted to them by order dated 14/6/2025. 11/6/2025 is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact. Send back the case diary. This anticipatory bail application is accordingly disposed.
Public. 51.
Who is for the petitioner?
Appearing is really for the person who directed the petitioner to some copy, but I am not getting a copy.
We'll dismiss this.
Our CD is there.
Case diary is there. Materials are
Materials are there.
what to do. We'll dismiss it. Heard Mr. K.K. Das, learned additional public prosecutor, as well as Mr.
Yeah.
K.
K.M.
K.M. Alam.
Hello.
K.M. Haloy, learned counsel for the respondent number, learned legal aid counsel for respondent number 2. None has appeared for the petitioner on call. Learned additional public prosecutor submits that the case diary is available. One chance is the case diary is available. Let this case be listed on 11th of when? 15th. Let this case be listed again on 15th of September. Let the case diary be retained till that date.
54.
Second bail application, Mother. It is not available. Perhaps Mother, first sheet has already been submitted. I cannot confirm, but Mother, maybe.
A sheet.
First sheet, I have not found any instruction on that.
No, if it is submitted, then you appear before the.
I do not have concrete information, Mother.
What is to be done? Let him
Then
take,
get it.
let him inquire.
Yes.
Heard Mr. S. Das, learned counsel for the petitioner. Also heard Mr. Bish K.K. Das, learned additional public prosecutor, who submits that case diary is not available. On the other hand, the case diary is not available.
11.
Yes. And prays for a short date for production of the same. Prayer is allowed. Let this case be listed on 11th of September.
Hello.
57.
Wait, please, hold on.
57 Anu.
57 and 57 and 65 will be taken together. Madam.
You are counsel in both the cases?
Yes.
Okay. 65 of them. Yes, what is this?
Made, please, your lordship. My lord, actually, affair is this, that police got information, Polton Bazar police, that a truck standing in front of, in the Bibarua road with 16 number of bulls. And they came
60
and,
numbers of?
my lord,
16 numbers of goats?
bulls.
Bulls.
Then police came, my lord, and found the vehicle along with the bulls and the driver of the vehicle. And accordingly, my lord, driver was arrested, cows were seized, the vehicle was seized. Now, your lordship, this petitioner, my lord, in item number 57, he is the owner of the cows. So, my lord, your lordship would be pleased to see the FIR at page 8 to 11. Now, my lord, that is the FIR. My lord, case is registered under many sections of law, my lord. That is section 11(1)(a), 11(1)(d). So, my lord, it is Prevention of Cruelty to Animals Act 1960. In these sections, my lord, only fine provided that 10 rupees like this. Now, my lord, another section added, that is section 13(1). 13(1), my lord, of the Assam Cattle Preservation Act 2021. Here, my lord, punishment provided for 3 years. It's non-bailable as per BNS. And now, my lord, here, my lord, main section, my lord, is the section, my lord, theft 3032 of the BNS. And 317 to receiving stolen property, that is for 3 years. And for theft, my lord, 1 year. Now, your lordship would be pleased to turn to page 12.
Yes.
So, my lord, these are the receipts, my lord, whereby the petitioner purchased the cows. Now, page 12, my lord, three cows. Now, my lord, page 14, another 3. Page 16, another 1. Total, my lord, 11 cows. The receipts are there.
Yes.
So, my lord, my humble submission before you, cows are seized. Cows are seized. Cows are in the custody of the police in some Goshala. And vehicle also seized, my lord. Drivers arrested, my lord. So, my lord, police is after me because I purchased the cows. I purchased validly purchased the cows. So, my lord, there is no offense on my part.
If I look into the CD lordship, if I from the firstly or from the CD lordship, it's seen that the vehicle from where the cow bulls were found lordship, the number is not there, registration number is not there lordship without number plate. Secondly, lordship, at the point of occurrence lordship, they could not able to provide any permit lordship, and documents were not also not given lordship. And in the statements of this driver lordship, he has stated that he has went to the place, that is the person Safikul lordship, item number 65. From his house, these bulls were loaded lordship, and they went to 9th mile, lordship, Meghalaya, to sell this bulls lordship. And moreover, lordship, he was also with the petitioner, sorry, lordship, driver. He is also in the truck lordship, but he ran away after seeing many people. No, it is in the statements lordship, not in the FIR. Moreover, lordship, this person, the petition number item 57, Lordship, Osman Ali. This person, a wife of the owner of this truck. She stated that this person is also involved in this case, Lordship. He also earlier also from 2 years, since 2 years, for 2 years, Lordship, they were doing this. So in my opinion, materials are there, Lordship.
Osman is not the owner of the truck, Mary.
No,
Owner
I
of
am
the
not
truck
saying
is
Usman-
Nozrul Haq.
No, Nozrul Haq's wife, Lordship, stated.
Nozrul Haq.
Nozrul Haq also stated, Lordship.
Nozrul Haq is the owner.
Lordship, I have already.
I am not the
stated-
owner of the truck. And my lord,
Lordship, this is all the things that is there in the CD, Lordship.
Heard Mr. M.A. Sheikh, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Osman Ali, OACH, Osman Ali, who is apprehending his arrest in connection with Paltan Bazar PS case number 220/25 under section 11 within bracket 1 within bracket A /11 within bracket 1 within bracket D of Prevention of the Prevention of Cruelty to Animals Act 1960, read with section 13 within bracket 1/16 of the Assam Cattle Preservation Act 2021, and also under section 3 within bracket 5/303 within bracket 2/317 within bracket 2 of BNSS. The gist of accusation in this case is that on on 1/8/2025, one Nobojyoti Sangmai had lodged an affair before the officer in charge of Paltan Bazar police station, inter alia alleging that an information was received regarding parking of a vehicle loaded with cattle in front of Bibarwa College. Stop. Accordingly, a police team went to the spot and found a vehicle without registration number plate was parked in front of Nehru Stadium at Paltan Bazar. In front of Nehru Stadium under Paltan Bazar police station. The driver of the vehicle, namely Abul Ali, was found in the vehicle, and on search of the vehicle, it was found that it was loaded with 16 numbers of bulls, which they were tied with a rope with no water or food grain in a very congested manner. Stop. Learned counsel for the petitioner has submitted that the petitioner is the owner of the cattle within bracket bulls seized in this case. He submits that he had purchased the cattle at Bagbor market under Borpeta district, and to prove and to support his submission, he has produced the purchase receipts of the purchase receipts of the said cattle. He also submits that the petitioner is ready to cooperate in the investigation. And he further submits that as the cattle have already been seized, as well as vehicle in question has also been seized, there may not be any necessity of custodial interrogation, as the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Paltan Bazar PS case number 220/2025 and has opposed the grant of anticipatory bail on the ground that there are sufficient incriminating materials in the case diary against the present petitioner. He also submits that what is the progress?
Progress is, they sufficiently progress, the
He
case
also
is
submits
pending
that
for.
otherwise the investigation has fairly progressed. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary of Paltan Bazar PS case number 220/2025. The documents produced by the petitioner in this case shows that he had purchased the cattle from Bagbor Animal Market at Borpeta. Further, it also appears from the case diary that the cattle as well as the vehicle involved have already been seized and the investigation has fairly progressed. Stop. Under such circumstances, this court is of considered opinion that if the petitioner cooperates in the investigation, his custodial interrogation may not be necessary for fair completion of the investigation of the above noted case. In view of above, the petitioner, above named petitioner is hereby directed to appear before the investigating officer of Paltan Bazar PS case number 220/2025 within a period of 7 days from the date of this order, returnable date of this order, and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with aforesaid case, he shall be allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Number 1 and number 2. This bail application is accordingly disposed of. Send back the case. 65 is almost similar. Only different submission is 65. Other things will remain same. Learned counsel for the petitioner has submitted that the petitioner is the registered owner of the seized vehicle.
No, my lord, I have been implicated by the driver that I was in the truck, but I fled away.
You are not registered owner.
I am not the owner.
Okay.
Owner
From
is
his house,
somebody
lordship.
else, my lord. That
From
is
his
the
house,
owner.
this
Owner is, my
loaded-
lord, I'm
full
giving.
loaded, lordship.
Honor is Nozrul Haq. Honor is Nozrul Haq.
What is your submission? You are not involved.
I'm not involved, my lord. Only driver, when driver was arrested, driver implicated me. And driver was arrested and now he is on bail. He is released on bail. So, my lord, on the
Is
statement of driver, I
learned
am,
counsel for the
police is after me. my lord.
petitioner submits that the petitioner is in no way involved in the offense alleged in this case. He submits that he has been implicated on the basis of the statement made by the co-accused, namely, driver's name is
Driver's name is, my lord,
Ali, Ali, Abdul Ali.
Abdul Ali.
Abdul Ali, who is the driver of the seized vehicle. He further submits that the petitioner, that the driver on the basis of whose statement the name of the petitioner has been implicated in this case, has already been granted bail. Has already been granted bail. Stop. He also submits that he is ready to cooperate in the investigation. Additional public prosecutor, London additional public prosecutor submits that there are sufficient materials in the case diary against the present petitioner. He submits that the present petitioner was one of the occupant of the vehicle when it was intercepted by the police. However, he escaped from the spot after seeing the police.
From his house, this wood.
He also, learned counsel for the petitioner, or learned additional public prosecutor also submits that there are also materials to indicate that the cattle were loaded in the seized vehicle at the house of the present petitioner. Baki, I will make necessary changes. 30,000 with one signature.
Much of it. Item 41.
May I please, Your Lordship? This is the case recovery of suspected cannabis. And the LS section is section 20B, Roman 2, capital A of NDPS Act. That the maximum.
B2A.
Yes. 20B, Roman 2B. Maximum punishment is up to 10 years, my lord.
How much is the contraband?
1.950 kg suspected cannabis.
Suspected?
Cannabis.
I need to call.
So, the maximum period of detention is 60 days in that way, my lord. Already 57 days in custody, my lord.
Oh, you are in custody.
Yes, my lord. 57 days.
Item number? He is behind the bars for 57 days.
FSL report is not yet received, only.
It is pending for FSL report. Heard Mr.
Yes, sir.
P.K. Sharma, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Ramlal Shah, who has been detained behind the bars since 14/7/2025 within bracket for last 57 days in connection with Panbajar PS case number 234/2025 under section 20B2B of NDPS Act 1985. The gist of accusation in this case is that on, where is the affair?
Affair, Lordship, page 10.
That on 14/7/2025, one Pranab Kumar Deka had lodged an FIR before the officer in charge of Panbajar police station, inter alia, alleging that on getting an information through reliable sources that a person would be carrying suspected ganja in a scooty and would be traveling by ferry from North Guwahati, a team of police personnel was constituted and it rushed to the spot. At the spot, the petitioner was apprehended And during search, no, not at this spot. Just to this spot. During the Naka checking at the route which leading to Rajadwar Ferry Ghat, the one TVS Jupiter scooty bearing registration number AS01GF 3836 was intercepted, and on the said scooty was driven by the present petitioner. On search of the said scooty, 1.950 kilograms of suspected ganja, within bracket cannabis, was recovered from the petitioner. Learned counsel for the petitioner submits that the petitioner has been detained behind the bars for last 57 days, and considering the fact that only intermediate quantity of contraband is involved in this case, the maximum period of detention during investigation period is only 60 days. And therefore he submits that considering the period of detention, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Panbajar PS case number 234/2024.
25, my lord.
2025, and has submitted that though there are sufficient incriminating materials against the petitioner, however, the investigation has fairly progressed and it is pending only for receipt of the forensic laboratory report. I have considered the submissions made by learned counsel for both sides. Considering the period of detention, as well as fact that the investigation has fairly progressed, this court is of opinion that further custodial detention of the petitioner may not be necessary if he cooperates in the investigation. May not be necessary for fair completion of the investigation if he cooperates in the same. Or in view of aforesaid reasons, the petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Special Judge Kamrup Metro, with following conditions. Number one, number two. Send back the case diary. This bail, anticipated bail application is accordingly disposed.
I'm deeply obliged.
Yes.
Interim was there, my lord.
Heard, Mr. What is your name?
SS Ahmed.
SH.
SS Ahmed.
SS Ahmed. You have appeared before the.
Yes, your lord. Statement of the accused has already been recorded.
Heard, Mr. S. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, as well as Mr. A. Ahmed.
Interim is there 23 2000.
A. Ahmed, learned counsel for the informant, this one, learned counsel for respondent number 2. When you got the interim?
23, 20/03/2025. 20 of March. AB number 416/2025.
Learned counsel for the petitioner has submitted that the petitioner was granted interim bail by a coordinate bench of this court on 23/2025. And in person to the directions of this court, he has appeared before the investigating officer and his statement were also recorded. On the other hand, Learned Cake, additional public prosecutor, has submitted that though the as the petitioner, as considering the fact that the charge sheet has been laid, as well as considering the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim bail granted to the petitioner on 23/2025 is hereby made absolute, with a condition that no, let the trial proceed. What allegation? No, is he abusing the?
At that time, some photograph has been taken by the.
No.
petitioner. And
After
afterwards-
considering that coordinate bench has granted interim bail, now it can be vacated if you can show that he has abused the liberty. I have for on what ground? क्या लिखा? Yes, what is your objection?
Paragraph number 3, 4, 3 and 4.
That there are materials.
I number 273.
Yes. What is your submission?
In before here's a student of this. Here the student of this petitioner, but at that time we have developed the lab affairs and Lordship has taken some intermediate movement and captured some photograph in intermediate movement, Lordship. After that, Lordship, when the victim was married another person, and the petitioner also sent those photographs to the victim's family.
Okay, let him face trial.
Lordship, as per FIR, the date of birth.
No, we are not going into merits. Whether he has abused his liberty after getting interim, has he threatened you? Okay. उससे पहले लिखना, before this, before that paragraph. Though learned counsel for the respondent has objected to the making of interim bail as absolute on the ground that there are sufficient materials against the petitioner on record. However, as there is nothing on record to suggest that the petitioner has abused his liberty after getting interim bail, or that he has threatened or tried to influence the victim girl in any manner. Stop. Moreover, considering the fact that the petitioner has complied with the directions of this court, then Baki add kar dena. It is made absolute.
Obliged.
Next, the interlocutory in I, you mentioned that in view of disposal of the anticipatory bail application number 416/2025, this interlocutory application is also disposed.
Himachal.
Condition that he shall cooperate in the trial.
Please, your lordship, she did not receive your honor.
CD.
She did receive your honor.
CD is there.
For extension.
Already disposed of your lordship. I has been already disposed of.
Item number
59.
59, there is no I. Huh? Yes.
I disposed of it.
Heard Miss, what is your name?
HG Daisy.
H.G. Daisy, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, who prays for some more time for production of the case diary. Prayer is allowed. When? Let this matter be listed on 23rd of September. Yes, why it is listed in something now?
Item 60
Oblige,
and
your
61.
Please, these two matters, just a minute. I understand you will take time. I know. This is actually, I know that they will take time, but I want to place something, your lordship, 2-3 things. What has happened, your lordship, in this case? Actually, I wouldn't have stated all this matter is actually with regard to amount to have been paid to the petitioner in the second case. The first case is the husband, second case is the wife. I am the petitioner in the second case, the first case. What has happened, your lordship, here? An amount of rupees 12,000 has been given, sorry, 15,000, 16,000, 15,000 has been given as a no, it was been given, your lordship, for per month.
You are husband.
I'm the I'm the wife.
Your wife, okay.
I'm the wife. We have challenged for, it was earlier 25. They wanted it to be 50, and therefore they came before this honorable court. Honorable court directed that the amount, half of the amount should be paid as interim. That part is okay. We are not on that. But what has happened, your lordship? Along with that, there was an initial, your lordship, order of divorce, and thereafter there was a challenge before this honorable court, and this honorable court in the division bench have given a judgment. In the judgment, 3 things have been specifically indicated. Number 1, your lordship, is that there was a insurance policy which on maturity should be given to the daughter of this lady and the husband. That amount, there was a direction. If that is not paid, then 9 lakh has to be paid. But secondly, your lordship, the amount was fixed at 6,50,000. That was ultimately paid in 2-3 installments. It was ultimately paid. And thirdly, it was given that the education and other expenses of the child will have to be borne 50% by the husband and 50% by the wife. The wife actually is a lawyer in the lower court, your lordship. So that was given.
Wife is a lawyer?
Yes, he is the advocate of the lower court, your lordship. And now what has happened, your lordship? Now, actually, I wouldn't have stated what has happened on the last occasion when the matter has come up. Prior to last time it did not reach. Prior to the last, the counsel for the husband came before the court in the morning and adjourned the matter and did not take my permission. And he came and told me that I have taken adjournment for filing an affidavit. Again, there's an affidavit. I went to the Lordship Justice and told that this was done. Lordship Justice told me that actually in the court he submitted that he's informed the other side. That is why I passed the order. I said no action taken anyway. It is not. Now what has happened, your lordship? He again filed another matter recently in, I think another case has been filed. That was case number criminal revision petition 351 of 2025. And in that case, your lordship, what has happened? In fact, before that, already since these amounts have been pending for a long time, 50% for the educational purpose has not been paid from 2000, I think, 21 or something. That has not been paid. And that is why there was a huge balance. Now what has happened? This lady has approached the execution court, and the execution court directed at a point of time that you pay 3 lakhs something immediately within a period of time. Against that, he came and filed an application. We are not served any copy. And an interim order was taken that you pay only 1,50,000. Now 1,50,000 he has paid. Now this amount has gone
That
beyond
is a different revision petition.
the second revision petition. I've got the order of that, but that too without our knowledge. So very recently, that is on 28/8/2025. Now thereafter, once again, the matter came up before the lordship where the earlier adjournment was taken, but that did not reach. Today it has come, your lordship. This is why I'm trying to point out.
What is the matter in this case?
This case, your lordship.
There are two revision petitions.
Two revision. One is they're challenging the amount that has been given.
Amount of the
amount that has been given.
maintenance
Amount that
of
has been given.
25,000.
No, 25 was the amount which we wanted, but that was not given, your lordship.
Ultimately, what was given?
That was, your lordship will kindly find that in the 13,000 that your lordship will find in my criminal revision, second one, your lordship. I'm just taking up the second.
167 is filed by them.
167 is filed by
You
us.
you have filed.
It's filed by us. In that, your lordship will find the order at page 78. The operative part is at page 11, your lordship. Oh, sorry, page 88. Here, your lordship, the amount was given as 13,000 per month to be reasonable maintenance to be
This
paid.
was under 125.
That was what they came up. They came challenging the other writ petition, other criminal petition, revision petition, where they have challenged that this amount. Then they got an interim order where it was brought to 50% to be paid in the interim. Now this 6,500 they are paying now, intermittently, but they are paying somewhere or the other. Now in my case, we have come for enhancement of, but in between we have also filed the IA on the basis of the division bench order, wherein this honorable court, your lordship will kindly see the division bench order also. That your lordship will find at page.
Why you have filed
73.
IA?
I have, because the total amount which was pending has crossed more than 10 lakhs. That is why.
No, then you go for execution.
That execution has come. Against that again, that is what, your lordship. That is why we have come. By filing one IA, bringing on record the amount which has already accrued because of the basis of the same case, your lordship, with regard to the same case, the execution, this proceeding.
Then
and
that criminal revision should be tagged with this case.
that also have to be tagged, but at least I want to point out one thing, page 73 for a moment, your lordship. They are not paying anything, just after every year, a little amount is being paid. Now 73 is the judgment, original judgment that before this honorable court. I'm just pointing out one thing. I will accommodate them. It is not that I'll not accommodate, but these things are something which I want to point out. That is why I'm submitting you. Page 73 is the judgment of this honorable court. That is in 2014.
No, 73 in which case?
73 in this case, 167.
167. Give.
One 73 page. This is the division bench judgment of this honorable court, 9/4/2014, your lordship. This is why I'm pointing it out here. Here, your lordship, you will see the operative part that I will come to your lordship is at page 76. Page 76. I'll not read the factual part. Page 76.
Yes.
Here, your lordship will see the first, second, third paragraph. it is therefore direct. I'll just read this. It is therefore directed. Lordship has got that.
Yes.
Page 76, the third paragraph. It is therefore directed that appellant shall pay a sum of rupees 6,50,000 towards the permanent alimony to the respondent less an amount of 4 lakh which has already been deposited before the registry of the court pursuant to the interim order passed by this court. The appellant shall also deposit 50% of the cost of education of the minor child and shall also continue with the insurance policy number so and so with the sum assured of rupees 5 lakhs. The appellant shall also continue to pay the maintenance allowance to the minor daughter as directed by the court under section 125. It is, however, made clear that in the event the appellant at any point of time fails to continue with the policy by paying the required premium, the appellant within 1 month of such failure shall deposit a lump sum amount of rupees 9 lakh in the name of the minor daughter in any nationalized bank having branch in Guwahati. To ensure compliance of such direction, the appellant shall send a copy of the insurance policy premium payment receipt to the respondent by registered post with AD within 2 days from the date of making such deposit. The appellant shall pay the remaining amount of 2,50,000 in 5 equal quarterly installments commencing from so and so. In case of failure to deposit any of the quarterly installment, as aforesaid, it would be open for the respondent to file appropriate proceeding for recovery of the balance at a time. It is further directed that the responsible shall inform the appellant before 15 days of the date fixed by the authority to deposit cost of education of the child, and the appellant within 1 week thereafter shall make 50% of the cost to the respondent so that she can deposit the entire amount together with her share with the authority of the educational institution concerned. The appeal is accordingly allowed, so and so. Now what has happened, your lordship? 2 things have happened. The 50% that they have to pay as per each year of the educational, your lordship, admissions and whatever fees and all, that was not paid from a very long period of time. That is why I filed the IA. The IA, your lordship will see from the period 2021.
What relief you are seeking in
Now, here 2 things, your lordship, only 2 things. The IA, just for a moment, I'll come to that. Page 5 of the IA. This is the chart. Page 5 of the IA. This is the chart, your lordship.
Yes.
Here from 2021 till 2025, an amount of 10,95,000 is to be payable. 50% of that will be around 5,47,000. They are entitled to pay 5,47,000. Now they should have paid that because we have already approached the executing, for this amount, we have approached the court, and there the court initially directed to pay an amount of 5 lakh or 3 lakh something. Against that, they came by filing the other application, and where they took an interim order saying that you deposit on a ground that the person has retired. But this was an order of the honorable direction of the honorable court division bench on 2014 itself. You are not paying from 2021. At that time, you are not retired. Today, you must have retired in 2025. He has retired, no doubt. Now, at this point of time, how can you dispute that these amounts will not be paid? You pay only 1.5 lakhs. This is one thing. Second part, your lordship, with regard to the insurance. Now, your lordship will kindly turn to page 82. This annexure I will show you, lordship. Here, your lordship, this is the insurance policy which has been mentioned in the division bench part.
82 of?
82 of the I.
Yes.
Now here your lordship will see, this is the policy. It has been downloaded from the internet, so clearly not there. But anyways, I'm trying to point out 2 things, your lordship will see. Maturity amount. Maturity amount is 7,88,000. And the date is 28/5/2025. 28/5/2025. Now, this also they have not paid. This also they have not paid. Now, this already matured. Court says that if you are not pay the insurance policy, you have to pay 9 lakhs within a period of 30 days. Now this also, after even maturity, we did not say anything till then. Now even in after maturity of this amount, they are not paying this. This is the issue.
Then
And
you
now
have
this
to-
order has
You
been,
have to go to executing court.
we have gone there in the executing court, and what has happened, your lordship? In view of the order of the executing court, this has order has been passed.
But this order has been passed in
Another case. Now that is why I would like to pray that this matter also should be tagged along with this.
Yes.
Because this is the way they are this was passed. We were not even informed about it. I am not blaming anyone, but how they are trying to manipulate things.
Okay, yes.
This is the issue. So that is why
Now
I'm
you-
placing everything in this court.
No, yeah, but that record has to be before this court.
That is why I'm saying that it should be.
What
brought.
is your submission? Why are you praying for adjournment? Okay, heard Mr. Y.S. Mannan, London Counsel for the petitioner slash applicant slash petitioner. Also heard Miss Singfo. But what is your name?
Your name.
What is your name? Tin Lu, London Counsel, appearing on behalf of Mr.
RM Das.
Mr. Whose behalf you are appearing?
RM Das is here.
R.M. Das, London. R.M. Das, London Counsel for the respondent in criminal revision petition number 167/2024, as well as for the petitioner in criminal revision petition number 345/2025. Learned counsel for the petitioner has submitted that during pendency of this court, these above mentioned criminal revision petitions, the petitioner has also filed another criminal revision petition, that is CRP number, criminal revision petition number 351/2025, in which by order dated 28/8/2025, ex parte stay was granted no 28 by order dated 28/8/2025, the amount of money which was directed by the learned Principal Judge Family Code number 1 to be paid by the respondent, to be paid by the petitioner in criminal revision petition number 351/2025, namely Shri Bhaven Kumar, that is rupees 3,14,627, was modified to rupees 1,50,000 without giving any opportunity to the respondent of that case, namely Srimati Rinti Deka. Learned counsel for the petitioner.
In fact, the order of the court, family court has not been stayed. It has been stated that with the court,
No,
the order will
not stayed, it was modified.
not stayed.
Modified. Learned counsel for the petitioner has further submitted that the execution case, criminal execution case number 137/2015 has been filed by the petitioner Srimati Rinti, seeking execution of the directions given by the division bench of this court in criminal appeal in
Met appeal
Met appeal number
13 of 2014,
13 of 2014 in its judgment dated
9/4/2014.
9/4/2014. However, the petitioner, apart from paying the interim maintenance allowance of rupees 6,500 intermittently, has not complied with the directions of the division bench of this court. He therefore submits that the criminal division petition number 351/2025 may also be tagged with the present, tagged with the aforementioned cases.
Even the insurance part has also not been paid.
Yes. उसके पहले learned counsel for the petitioner has also submitted that the respondent Bhuven Kumar was also directed to continue to pay the premium of insurance policy. Insurance policy
or its number is stated in the division bench judgment itself. That is 48545499.
policy number
48545499. At the space 76, will not that paragraph.
485454,994. He submits that the said policy has also matured. Has it matured?
Matured on 28/5/2025.
Has already matured on 28/5/2025. However, neither the amount of the said policy, maturity amount of the said policy was given to the daughter of the petitioner, nor the default stipulation, that is 9 lakhs, have been paid by the husband of the divorce has been granted.
Yes.
By the respondent Bhuven Kumar. Therefore, tag wala paragraph le ho. Leaves this matter when after
4 years.
16th October. Let this matter be listed on 16th October.
Can it be before the vacation, your lordship?
Before the vacation, there will be too much rush of cases, fresh cases. It may not reach. And your case requires time to be heard. So let it be on 16. You are getting only 6,500.
6,500, and now after the interim order by the Honorable Court in the other, they have given that 1
1
lakh.
lakh.
That now they have given. So I think
Okay.
3 days, 4 days back.
Yes. What interim was granted?
That's 6,500 in
Okay.
that other.
The interim order shall continue till next day.
Obliged.
Item number? Data set. None has appeared for the petitioner on call. Let this matter be listed again on. Scan copy is there or not? Okay. Learned Mr. K.K. Parashar, learned additional public prosecutor is present. List this matter again. Before vacation attended on 19th.